Sorry, we were late because we just. Yes.
Well, it may be permitted to mention an order of 19th March 2025
For correction.
no, my lord, for my lord had directed the receiver to execute the deed by 17th of April. Unfortunately, his father has passed away on 5th, my lord.
It will appear as to be mentioned, Mr. Ganguly. Will.
My other side is here, my lord.
Oh,
Siddhartha Ghosh is the receiver. His father has passed away last Saturday.
We'll pass an order extending that, but we generally prefer not to pass orders without the matter being on the list because there has been several malpractices previously on that count. We are being very candid.
Okay, order to be
Let it appear in the list. We'll pass a formal order. We'll condone this period and extend.
My lord, I may be permitted to mention one
Yes, please.
hearing matter. My lord, paper books are ready. My lord,
Appellate side.
my lord, appellate.
Wait for the original side matter to be over. It will be over soon.
To be mentioned tomorrow?
No, next Wednesday.
Next.
Yes. We'll take care of this period in no difficulty.
Your Lordship, may I be permitted to mention one matter for modification?
Original side.
Appellate side.
Appellate side. Wait for the appellate side. Only one matter after. Yes. Yes, please.
My lord, only one thing before my learned friend proceeds, my lord. I have a preliminary point, my lord. So if I can place before your lordship, he can address.
Yes, he can address that also. Mr. Dev, please take the microphone. Yes. Yes.
The order which has been challenged before this honorable court, my lord, is an order passed under Section 7 of the Religious and Charitable Trust Act, allowing the petitioners to sell a property.
Right.
And that order has been challenged. Now, my lord, I find there is a clear bar under Section 12 of the said Act.
Have you got a copy of
Yes,
this?
yes.
And what is the other appeal about? Two appeals?
Identical.
order, Your Lordship.
By the same appellant?
Yes, 5 persons objected, 2 preferred one, 3 preferred second.
Yes, boita din. You have got 2 copies. Thank you.
Yes.
So you are prepared for this point, must be.
Yeah, I know that because it was being heard by the other division.
Obviously,
Then it
yes.
was released, my lord. So, barring of appeals, if lordship,
Section?
12.
12.
Barring of appeals, my lord, no appeal shall lie from an order passed or against any opinion, advice, or direction given under this act. Now, my lord, the order which
No,
is
this is religious endowments or charitable?
under Section 7 of
Which
the
act?
Charitable and
and
Religious Trust
Religious
Act. It's an application filed seeking court's permission to sell a property. It was a
Right.
trust property, private trust. Shevites came forward and court allowed, hearing everybody. Now, my lord, what I respectfully submit, my lord,
No, sorry. This is the under the Charitable and Religious Trusts Act.
yes,
Yes, sir.
application was filed under Section 7, seeking court's
Section
permission.
11, yes, barring of
Section
appeal, right, right. No appeal shall lie.
Yes. Now, my lord, it's an opinion of the court that there was a legal necessity, which, my lord, culminated, my lord, permitting, my lord, in the sale. So that's
So whether this covers a letter patent appeal
yes, I
or
have got
not.
a judgment, my lord, not of this honorable court, but of Delhi High Court. It said it's not a clause 15 appeal. Only provision under which the appeal can be filed is a clause 15. It says, my lord,
Yes.
clause 15 appeal is not maintainable, my lord.
But
78
there is a specific bar.
because of the specific bar. 78 Delhi, my lord.
Hmm.
74. I have a copy, my lord. Kindly seize, my lord. I will place and give it to my learned friend so that he can rely on my specifically bar. Okay. I have other points to argue, my lord.
No,
on
definitely.
merits.
This is only on the material.
My lord, kindly, my lord, consider, my lord, paragraph 9 straightway. This was also an order passed under Section 7, identical matter, my lord. Paragraph 9, if lordship sees, my lord, of the
Yeah.
judgment, may I, my lord, place it. It was next urged that the appeal would be competent under letters patent. Lordship has got it, my lord.
Yes, yes.
Letters patent of the lower high court as the application applicable to the High Court of the Punjab and in turn made an applicable to the High Court of Delhi. Here again, in our opinion, the submission is without force. If a petition is filed under special statute, then the provisions of that statute alone would govern the proceedings. It will not be possible to invoke the letters patent to urge a right to file an appeal, as we have noticed Section 12 of the Charitable Religious Act specifically bars an appeal. It has been held that no appeal lies against an opinion given under Section 34 of that, therefore to invoke assistance of the is futile. He can have a look at this judgment.
Thank you.
I will address on other points. Also.
Yes. On merits later. Yes.
Only
Yes.
one difference, Your Lordship. I know, Your Lordship, this
To
point
overcome
I have
this.
taken. Lordship, kindly take, Your Lordship, the Section 7 of the, Your Lordship, the same Act. In this particular matter, Your Lordship, what has happened? Section 7 has been filed by 2 Shebayats. Now, I understood, Your Lordship, that Section 12, if there is an opinion direction, Your Lordship, the Shebayats cannot prefer an appeal. But in this case, your lordship, I was not the applicant. I was, your lordship, the person who is supposed to give the notice as per section 7. Your lordship kindly sees section 7 of the Trust Act. 7.1 and 7.2 deals with the application. Now 7.3. On any date fixed under subsection 2 or any subsequent date to which the hearing is, the court before giving an opinion advice shall afford a reasonable opportunity of being heard to all persons appearing in connection with the petition. This has happened. Notice was published. I appeared before the Honorable Court, but your lordship, my objections have not been taken because I am not a Shibayat. The reason, your lordship, is any worshipper, your lordship, because lordship knows, your lordship, the deity or an idol is a perpetual, your lordship, minor. Any person, your lordship, a next friend to God or a worshipper can come before the Honorable Court and challenges those particular orders. Now, what happens, your lordship, in this section 7 matter, the properties are not alienable. The exception is section 7. When the Shibayat comes and file an application and shows that there is a legal necessity as well as it should be for the benefit of the idol. In this particular matter, your lordship, what is my challenge is, the Honorable Court, first of all, your lordship, rejected that I am not a Shibayat, so that's why, your lordship, my objections are not tenable. And thereafter,
the language of section 12 is very wide. It's not only against any advice, opinion. No appeal shall lie from any order passed or such and such under this act.
Lordship,
So
I've
this is
seen that
an order passed under. Yes, the position would be otherwise if no provision of appeal was there. We could appreciate that. Where there is a gap, we can invoke our latest patent appeal rights. Definitely. If there is no provision in the statute, latest patent itself gives that right. But in the teeth of a bar in the statute, which creates that right under section 7, we think it would not be prudent to entertain the appeal on that count. Because we are rather agreeable with the, this is the Delhi High Court. Delhi High Court. Because it's not very elaborate, but we can give the reasons, further reasons also. But we are not trying to shirk our duty. Rest assured on that. But this would create a bad precedent, because if you override a specific bar in a statute, and the reason, as we have said, that there is a specific bar, appeal is in respect of an order passed on a right which emanates from the statute itself. So it has to be governed by the statute. If there was no bar, there was no provision of appeal, we would interfere, definitely.
I checked yesterday also regarding clause 15 and section 12. I could not find. I found this particular Delhi High Court judgment. Lordship, if it is not maintainable, I have
It's
no other
persuasive.
option
It's persuasive.
but to go, your lordship, only before the apex court. May I, your lordship, seize your lordship and come back? If there is no judgment, I'll
If you could not find out last night, you won't be able to.
I could not find. I could not find. Because merits, I have a very good case.
No.
But your lordship, in connection with the section 12 bar, I could not find, your lordship, that there is a
Either way.
exception to clause 15, so that I can prefer clause 15 appeal.
If this was a judicial review under the constitution, it would be different.
Lordship,
But latest patent is also a statute. So within the umbrella of the constitution, these are parallel.
I leave it to your lordship whether your lordship will give me a date or your lordship will decide this.
No, no, we'll
because I
decide.
could not find it, your lordship.
No use keeping it pending at all. At the outset, comma, an objection as to maintainability of the appeals is taken by learned senior counsel appearing for the. You are for which respondent?
I am for the respondent numbers 1 and 2, Millard.
For respondent numbers 1 and 2. For sub next para, learned senior counsel submits that in section 12 of the Charitable and Religious Trusts Act, 1920, there is a specific bar to any appeal being filed from any order passed or against any opinion, advice or direction given under the Act. For sub next para, learned senior counsel also cites a division bench judgment of the Delhi High Court reported at AIA 1978 Delhi 274 within bracket Dr. Man Singh and others, in the matter of Dr. Man Singh and others, bracket closed, in support of such proposition. Puts up next para, learned counsel appearing for the appellant's contents that, what should you record as your contention? Because that does not pertain to that's on the merits of the.
Because your lordship, the applicants, your lordship, are not the appellant before your lordship. If there is an advice direction.
Submits that the applicants in the proceeding under section 7 of the 1920 Act are not the appellants before this court. For sub next para, it is contended that on a conjoint reading of sections 7 and 12 of the 1920 Act, it transpires that the person who applied under the said provision is bound by the bar as well. For sub next para, however, in our considered opinion, the bar under section 12 of the 1920 Act applies in full rigor not only to appeals preferred by the applicants under section 7, but in general, from any order, double inverted mode, any order, passed or against any opinion, advice or direction given under the Act. Push up next para, we are ad idem with the ratio laid down in the cited judgment of the Delhi High Court to the effect that since the 1920 Act and the latest patent both operate on parallel footing under the umbrella of the Constitution of India, and the latest patent appeal as provided for in the latest patent is not a constitutional remedy of judicial review, the same cannot override the specific bar as provided in a statute. That apart, since the orders passed under section 7 and or the rights conferred under section 7 of the 1920 Act emanate from the said provision, appeals or other challenges against any order passed under the said provision are also governed by the self-same statute. Next para, in the event there was no provision of appeal in the 1920 Act, we could very well have considered the provisions of the latest patent to carve out a provision of appeal insofar as the present order, the impugned order is concerned. However, we are loath to interfere by entertaining an appeal in the teeth of the specific bar provided in section 12 of the 1920 Act. Next para, accordingly, APO 16 of 2025 and APOT 50 of 2025 are dismissed as not maintainable. GA 1 of 2025 filed in both the matters, as well as GA 3 of 2025 and GA 4 of 2025 filed in connection with APO 16 of 2025 are also dismissed consequentially. Next para, it is made clear that we have not entered into the merits of the respective contentions of the parties, and it will be open to the appellants to prefer a challenge against the orders impugned herein before an appropriate court stroke forum, if law so permits.
But only one thing, an additional thing, my lord. Yesterday, my lord, they have served me a copy of an interlocutory application. The person whose favor, my lord, property has been sold, he should not create any third-party interest. So that should also be, my lord, dismissed, because in view of this, it has been served yesterday.
Another application is
Yes,
pending.
interlocutory application.
So I filed a GA
GA4.
application, your
So
lordship,
that could
because
also, my lord,
GA4 is appearing today.
oh, lordship is appearing.
it is
Very
appearing today.
Oh,
Only
I'm
one
sorry.
thing, if your lordship kindly considers, on the last occasion, 24th of February 2025, there was no interim order, but there is an observation that any steps pursuant to the order passed by the single judge will abide by the result of the appeal.
We'll
Only-
have to, we don't have any option but to say that any interim order, if any, stands vacated.
Lordship can pass it, but only because I have to go before the apex court. This is a deity's property.
After this
Properties-
finding, we cannot do that. That would be,
Only for a limited period.
How can that be done?
we cannot do anything.
If the property
We are
is demo-
functus officio once we hold that the appeal is not maintained.
Understood, but the
Not functus officio even. But we don't have jurisdiction ab initio. That is a difficulty.
I understood.
Otherwise, we would definitely have given some protection to it.
Otherwise
That
the
we can assure you and Mr. Dev.
building will be
but
demolished, then your lordship nothing will
We
remain.
fully empathize with your client, but একটা line add করে দিন যে interim orders, if any, stand vacated.
Grateful,
We are sorry to do that because you pointed out and we are
No. It's my duty, your lordship.
no.
Absolutely.
We are confident on that. Thank you very
Grateful,
much.
my lord.
Thank you. বইটা ফেলতে হবে। Mentioning call করুন।
My lord, I may be permitted to mention hearing.
What is this?
My lord, hearing matter, but there is a Supreme Court direction to dispose of this matter. The matter is pending since 2016, my lord.
Give us a copy of the direction.
My lord. My পেছনে আছে। My paper books are ready and it's. I'm for the respondent, my lord. I'm the land loser. Land losers are waiting since 2007, my lord. Landers were acquired in 2007.
Very well. It's a specific direction. Let it appear as to be, both sides are present here.
My lord, they are not present, but
We'll keep it as to be mentioned tomorrow itself,
yes,
and
my
we'll fix a date.
my lord.
We'll take
deeply,
note of this order.
deeply obliged, my lord.
Please keep these copies with you.
It's there.
Uh,
Yes, my lord. I
Keep
shall
it with you. Please hand it over when it appears as to be mentioned, so that we can rely on this and fix
My
a
lord,
date.
I shall.
Because other matters we are refusing.
My lord,
You have to give a reason for.
I shall, my lord.
Very well. এটা to be mentioned কাল দিয়ে দেবেন। হ্যাঁ। Please hand over a slip with the endorsement to be mentioned. Yes.
No.
Permitted to mention one matter for modification of your lordship.
Yes. Please mention.
My lord, to be mentioned tomorrow then.
Modification is to be mentioned. Modification on merits.
No.
Correction. Yes. To be mentioned too.
Some of 30 lakhs were to be deposited with the original side, your lordship, but it has to deposit with the appellate side.
Oh, absolutely. We'll do it. Give a notice to your other side if you can. Yes.
Lordship, on order 41 application in
Call on the list.
My lord,
You're mentioning something? Yes.
hearing matter, my lord, in
Hearing matter we are not adding. Sorry. Call on the list. জাজমেন্টটা কোথায়? জাজমেন্টটা কোথায়? দেখে দেওয়ার আগে দেখবেন না জাজমেন্টটা আছে কিনা? We are without our judgment. So we have even forgotten what we did. So please wait. We'll just pass it over. We'll call.
Yes.
টুপিটা পরে ওপরে খুঁজে দাও। Dean. Yes, we're passing it right now. One. Sorry. Yes. In view of the above observations, FA number 144 of 2017 is dismissed on contest without an order as to costs, thereby substantially affirming the judgment and decree dated May 17, 2014, passed in such and such, with the minor modifications as indicated below. The bank guarantee furnished by the defendant appellant with the learned Registrar General of this court, pursuant to orders passed in connection with the present appeal, shall be invoked by the learned Registrar General, and the amount obtained upon encashing the same shall be handed over to the duly authorized representative of the plaintiff upon being so approached, upon deducting the statutory charges. Since the said amount covers the principal decretal amount along with interest only up to the date of furnishing the bank guarantee, the defendant appellant bank shall pay to the plaintiff respondent within 90 days from this date the balance amount of interest at the rate of 6% per annum on the principal decretal sum calculated from the day immediately after the date of furnishing the bank guarantee till the date of payment of the same, in consonance with the impugned judgment and degree of the trial court. In the event the said balance, this is the modification against you. In the event the said balance interest is not paid within 90 days from date, the appellant bank shall pay to the respondent, in addition to such balance interest, further interest at the rate of 8% per annum on the amount of balance interest due as on the 90th day from this date, calculated from the 91st day from this date till the date such payment is made. So you have to pay the balance amount because trial court degree was till date of payment. You have paid up to the date of furnishing the bank guarantee. From that date till you pay 6% interest only. If you don't pay within 90 days, over and above that balance only, that balance interest, you have to pay 8%. This is the crux. Formal degree be drawn up.
deeply okay.
Thank you.
Grateful enough.
যাচ্ছে তো এখানে কালি ফুরিয়ে যাচ্ছে। এটা নিয়ে নিন তো, আমি আবার এটা দিয়ে লিখতে শুরু করব।
I'm for the appellant. My lord, there is 1 day delay in submitting a special messenger cost.
Oh.
Department is saying, my lord, unless it has been.
Yeah. On the oral prayer of learned counsel for the appellants, we condone the delay in depositing the special messenger costs. Let the same be, full stop, let the same be accepted. Full stop, the office shall take steps accordingly to call for the trial court records by special messenger as per our previous direction. Thank you. Not today. Not today. You're appearing. Other side is there.
What?
Other side is there.
No, my lord.
Appearing for the
This is
first
my
time.
Application for restoration of the appeal, my
No,
lord.
this is appearing for the first time.
My lord, before that, my lord, matter was appearing the single bench. My lord, single bench, my lord, was pleased to release the matter. And my
No,
lord,
not that.
leaving
We
it.
have directed to serve copy.
No, my lord. Now, sir, kindly see the order dated, my lord.
Order আছে,
26
না?
March 2025. My lord, CAN 9 is the, my lord,
This was dismissed at the order for 10 rule 11 stage.
yes, my lord. No, my lord. After, my lord, paperwork was filed, my lord, appeal was admitted and paperwork was filed. Thereafter, my lord, matter was dismissed for default
no,
with the Lojima bench.
It's a there is a substitution application.
Yes, my lord. Substitution application and also, my lord, restoration of
First,
appeal.
substitution has to be allowed.
Yes, my lord. Substitution, my lord, lordship, my lord, was
Which one is?
grant me leave. My lord,
We'll grant direct to which? What is CAN 8, 9, and 10? What are
my
these?
lord, CAN 9 is the, my lord, restoration of appeal.
Right? CAN 8?
8 is the, my lord,
Substitution.
my lord, condonation of delay, my lord. Application for condonation of delay for restoration of the appeal.
All right.
CAN 10 is the, my lord, substitution on the death of respondent number 2.
Mr. Ghosh, we'll direct you to serve copies of all these three and come back.
Yes, my lord.
Because substantial rights, section 5 creates substantial rights. So even before the admission, we have to direct you. The appellants shall serve copies of CAN 8 of 2023, CAN 9 of 2023, and CAN 10 of 2023 on the respondent, indicating that the applications shall be listed under the same heading on how soon can you serve? Tell us. We'll keep it on 28.
Speed post, my lord.
On April 28, 2025, when an affidavit of service to that effect shall be filed by the appellants.
Lord, in my lord, I have served, my lord, and it will do the service, my lord, also with me, my lord. But my lord, before single bench, my lord.
Serve again because they won't be knowing that it's appearing in the list. It will create problems. They'll make a recall application. Better serve and come back.
Lord, shall I serve upon the, my lord, respondent number, legal heirs of respondent number 2, my lord, because respondent number 2 is your death, my lord.
Oh, there are how many respondents are there?
My lord, there are, my lord.
তাহলে করে দাও ওটা respondents as well as the proposed substituted respondents.
Yes, sir.
কোনটা আছে ওখানে? Order for 2 Yes.
My lord, I am for the applicant.
Yes.
My lord, yesterday when the matter was called on,
Right.
my medical emergency in my
Oh,
family.
yes.
That's why I'm.
Now everything is all right in your family. Everything is all right in your family. Clarification.
But, what happened?
No, the respondents are not there.
Yesterday
They were there, you were not there. So 50-50, let us come back tomorrow.
His client is.
His client
Tell
will
me-
argue the matter
No. Client tell me that.
that he is coming. So we are passing it over, pass over. Whenever he comes, mention pass over.
My lord.
Yes, Mr. Bhattacharya.
Appellant, but my lord, one Raju Bhattacharya and another is lawyer. Today he is absent, my lord. So tomorrow,
We're just making it not today then.
Friday, my lord.
None appears for the respondents at the time of call. Although the appellants are represented, let the matter stand adjourned for the day.
I'm for the
Yes.
appellant, madam.
Yes.
It is a condonation of delay. In the
Mr. Ghosh, what is the delay? What is it?
delay of 7 years.
7 years only.
No.
What is the explanation?
Explanation.
You are for the other side.
Well.
What is the explanation? 7 years is quite some time.
Quite something, but the delay latches of the first ground, latches of the advocate.
This is against what sort of a degree?
What of the partitions?
Final degree.
Not in the
So dismissed or final degree?
finally.
Final degree has been passed against that.
Expert.
Ex parte final degree. It has not been executed as yet.
Not in so many another suit.
Executed.
Executed, my lord. Commissioner demarcated. Subsequently, my lord, decree passed. We are in our possession. They are in their possession.
Allotted. Commissioner, the final degree passed and allotted as
2006, my lord. 2006 August, final degree passed.
They
They preferred an appeal in 2016.
Well, paragraph
2006 is the
2006, 31st of August.
decree. So 10 years delay.
10 years, near about 10 years. my lord.
no judgment. Paragraph 13 is the ground. Another suit filed by the filed by the co-sharers in the same mentioned all those had.
You had filed that other suit.
I have not filed.
You are a defendant in this suit and you are a defendant in that other suit also.
Defendant also.
In both the suits, yes. So how can that be a reason?
Reasons were there is a kindly see the last was also mentioned in the suit that expertly against some co-sharers filed the partition suit and mentioned that this suit mentioned that suit is decreed in favor of the co-sharer. In favor of and the appeal preferred by the present opposite party.
Yes, the subsequent suit, we are the defendants. We took, my lord, that was decree, preliminary decree ex parte. Subsequently, we preferred an appeal. On the ground that
Preferred an appeal.
this property has already been partitioned by.
No, it was never disclosed by them there that this suit is pending. You had appeared, the preliminary degree was passed in your presence in the present suit.
In the present suit.
In the present suit, the preliminary degree was passed on contest.
Passed on contest.
Then you knew about the suit. So how can this be a ground? Another suit has been decreed.
In this appeal also, if this appeal is confirmed, then the other appeal is connection.
That cannot be a ground for the delay. What prevented you from preferring an appeal immediately? The decree was of 2006 in this suit.
Got copy of
Your
the
partition subsequent suit was itself of 2009. Mr. Ghosh, let us complete, then you answer. In 2006, the present suit was decreed in final form. Right?
2009,
after 3 years, you filed a different suit and that was decreed. How can that be a ground for not?
I have not filed different suit.
Whoever filed.
I filed in connection with.
How is paragraph 13 even a ground, a justification for the delay in not preferring an appeal against this?
I'm ground.
So what?
Advocate. That's just on the advocate of the.
Where is that?
I have stated every 5.
Read it out, Mr. Ghosh. We are not here to fish out grounds for you. You have to read out your grounds. We are not satisfied with 13. It has nothing to do with your present appeal.
No, not this appeal. This should have.
Second judge copy এখনো দেয়নি?
This.
কি করছেন কি আপনারা?
Paragraph 8. That is said information. Paragraph 7. That the landed court below has not given in charge to admit evidence of the government in ex parte degree in the government suit and also not given the court below.
So what?
That said information came to that in the ex parte degree in the month of December.
No explanation. Suddenly you.
Said ex parte degree was not in. Then the then advocate for the appeal lower court below ultimately then returned the brief to the applicants without any information regarding the ex parte degree.
It was your duty to inquire about the suit. The preliminary degree was passed in your presence. You knew about the pendency of the suit.
No, preliminary degree is also not also in my presence. Without any knowledge, without any knowledge, evidence, when expert degree was passed. Well, there is well, kindly see this the present suit. I have not filed. I am a matter party. But that is the
Whatever stated in paragraph 3, that your appellant was very much surprised they had no knowledge of final degree. Very well. These are on merits. You are represented by an advocate in the court below. You say that your advocate did not inform you. So you are represented by an advocate. You had appeared in the suit.
initially first thereafter about latches on the part of the finally not yet being informed, not in be communicated, and commission also in absence of the party. The present suit is coming is mentioned in the course as well. The paragraph. Another copy
সাবধান।
also given another copy.
পড়ে যাবেন না, সাবধান, তাড়াহুড়ো করতে হবে। This is which judgment?
Mention this earlier.
What are you handing up? What is this?
What is the subsequent suit? But we are the defendants.
Yes.
Made a party. But it mentioned in the said suit, kindly see the paragraph 8. That is the 82 by 90 suit number
89 by 92.
92. It is unless this suit is not the suit is not this it is dismissed, then all proceedings infectious. We are made the defendants. We are the made parties. So many parties.
When did you file this present appeal?
I have not filed.
Present appeal you have not filed?
Present appeal. Present appeal I filed in the 2016.
Yes, 2000 when? 21st of June 2000? No, not that.
2016 and on
10th of August 2016.
It is August. It is continuing.
What is continuing?
Continuing. Thereafter, another courser has filed a suit on the basis of same suit. It is expert degree. On the basis of the suit, also Nurul Islam, the present defendants, preferred an appeal against the said degree.
Why didn't you take out an ordinance rule 13 application?
I am not aware of the said thereafter. I am not aware of the said.
If you have preferred this appeal, you must be aware then at the time of preferring this appeal.
No, preferred an appeal. I have preferred on this appeal. Not
when
appeal.
You preferred this appeal, why didn't you take out an ordinance rule 13 application also?
It was already delays, so many delays.
Same applies to this appeal.
No. Same applies, my lord. I have preferred an appeal there. Another suit is there.
Because in ordinance rule 13, court could look into whether summons was served properly on you and all these things.
If it is dismissed, then my lord, kindly others.
This is done in a very slipshod fashion. In para 8, you say, though the expertise degree was not informed by the then advocate for the appearance in the lower court below, the sentence stops there. Ultimately returned the brief. So therefore, you admit that you were represented by an advocate in the court below.
Initially, I have not. Initially, it is the expertise. But initially, first time I made I have engaged.
So it's your duty to. It's a diligence of the client which is to be seen.
So many facts threatened by the other parties. So kindly.
No, Mr. Ghosh.
Other appeal.
7 years is too much. Not even 7 years. Almost 10 years delay. Why did you say 7 years?
Other appeals, they filed.
Whatever.
Got degree in favor of the course errors. Already then will be infectious.
Will be infectious. After 10 years, we definitely won't allow this section 5.
After filing the kindly see the another suit. They preferred an appeal against the degree.
Maybe they were diligent.
They preferred an appeal. So appeal is pending. Appeal is already mentioned that suit is.
We were the defendants.
We are the defendant and got degree in favor of.
They got the degree expertise.
In this suit, you are the plaintiff.
I'm the defendant.
Here it is recorded plaintiff's claim he had no notice about the
Also,
case.
Initially, we also defended, he also, this.
That is
also-
not found here. That is not observed here. This observation is with regard to the plaintiff in the second suit. That the plaintiff's claim he had no notice, and that claim is well founded.
They have made a party as a defendant suit. We are the defendant in the said suit. Whereas all suit is.
Sir Ghosh, in this subsequent suit judgment, it is observed by the trial court that in fact the plaintiff's claim plaintiff claim he had no notice about the case, which is well founded. But that is about the plaintiff. This finding does not govern you. You are the defendant.
Same cases, you have, kindly.
You have just out of the blue, you have castigated the advocate in the court below. We don't know whether you have not stated that.
So many facts in the.
Mr. Ghosh, you complete first, then we'll argue. Because we cannot both comment together. You please complete your sentence, then we have something to say to you. You complete whatever you have to say.
So many grounds there, I have not stated that threatened and I could not enter the village and commission was expert. I have not that mentioned, but could not enter the village and threatened outside. They were at the outside and the village and not yet been entered the village. So, but I have not mentioned that ground. I have mentioned the latches that have not yet been informed, and there is a judgment of restoration of 7 years. Justice in this court.
It has been held there that every 7-year delay has to be condoned.
Yes, 13 years.
Every 13-year delay has to be condoned. Any time limit has been given that this is a precedent on this. That if it's above 7 years, then it has to be condoned. That is on the facts of that case. The nota. One copy only.
Only 2 copies. But also recent Justice.
Justice Dhulia. There is a Supreme Court judgment also. The view is very liberal, but not applicable to.
My lord also consider other suit will be, if it is dismissed, then other suit of the other degree total on the basis of wrongful record.
Not after 10 years.
No, it is just recently when a justice Tapalpati Chok
Maybe
13 years. Delay of 13 years. So there is
no. You have not made out any ground for that.
I have stated in the ground. But if the present appeal, the present suit and appeal is there pending. So if the appeal is not this, then all others infectious. But so many wrongful record of not yet been. We have purchased the said land, but wrongfully in the suit property. Wrongfully mentioned in the suit property. So many litigations arises in the
in this case, the division bench judgment, a can was filed in respect of a dismissal for restoration of a case pending in High Court, and the court found that the person was a resident of Purulia, which is situated in a long distance, and he might not have known about that. But
yes.
This was in your district. This judgment was passed.
District this suit, my lord, this present suit and appeal. Now appeal is pending. So if it is dismissed, so other proceedings will go. Other suit and other liberty may be given to all and none, but
liberty to do what?
Others, the present suit and appeal will be in fact very considerable.
Let us see Justice Chakku.
No, kindly, there is other suit is also the appeal degreed in favor of the plaintiff. There is a separate suit. It will be will be infectious. When there is so many deeds purchased, question of plot mentioned in the wrong earlier degree. So is it difficult to record the rights? On the basis of said degree, but the other authority concerned relying on the said judgment. But in the degree,
no, here there is a delay of 3 years only.
No, 13 years, others, 13 years.
No, in this case, you have cited the case Justice Chakraborty's judgment, Tawabrata Chakraborty, praying for leave to prefer appeal against preliminary judgment and decree dated 24 January 2019. And this was filed in 2022. So 3 years.
Wrong, thereafter wrong, my lord.
Which portion? Place that.
Delay of 3 years, condoned, not delays. Thereafter, my lord,
No, here the pandemic period intervened. Pandemic, COVID-19 intervened. No condemnation is there.
General, another two Supreme Court judgment is my lord.
Cite those.
My lord also not, but it is
Not in every case.
No.
Not in every case, Mr. Ghosh,
my
definitely.
lord, it is a good. Yeah, my problem is the another suit is appeal is decreed in favor of the plaintiff. The same suit. So if the
You waited for that decree, Mr. Ghosh. Your
I'm not-
intention is malafide. You waited for that decree. Only after that decree was passed, you have preferred this appeal. You awaited the outcome of that decree. The other one you have handed over to us. That was passed in June 2016. When that was passed, after that you grew wiser and you were advised that if you don't prefer an appeal against that one, this will be toothless. That's why you preferred the appeal.
no, it is so he also other
This-
other courts. So it's no
The judgment which you have handed over, this is in respect of the same property.
same property,
Acha, here this went in your favor.
not in favor, not my favor. Also plaintiffs is not my favor. We are the defendants in the
Plaintiffs are the same.
plaintiffs of the same. Plaintiff is the Nurul Islam and preferred against the preferred and appeal by the Nurul Islam. The
No, this is someone else. Nader Hussain Sheikh.
Nader Hussain Sheikh, he was the defendant. We are also defendants in the
In the
in the
subsequent,
suit.
in the subsequent suit, we both were the defendants.
Yes.
Both are defendants. But the file, subsequent file was also the defendants and preferred and appeal. Preferred a file a suit.
You have preferred an appeal against this judgment also.
No. The first time I have this preferred an appeal.
This
My appeal.
the subsequent judgment you have
I
preferred.
have the defendant. In this case, I have
You have preferred an appeal against this judgment also, Mr. Ghosh.
they preferred this.
Then you are not aggrieved by this judgment, the other judgment, the judgment passed in 2016 in the other suit which you have handed over.
This is the file filed by the co-sharer. I made a party. You are a defendant.
Oh,
We are the defendants in the case.
you are defendant, that's why you cannot prefer an appeal.
This
We are asking you, are you aggrieved with the judgment passed in the other decree, other suit?
this suit. No, I have appeared in that.
What this suit, that suit we don't understand. You have handed over a judgment to us. This is in partition suit number 269 of 2009.
In the defendant. We are the defendant.
Defendant, you have told 100 times. This judgment was passed. Have you preferred an appeal against that judgment?
This judgment preferred an appeal against by the.
You have not preferred any appeal.
No, I have appeared. I have not preferred. But this appeal,
You are not aggrieved
I have-
by this the subsequent decree.
I made a party in this appeal also. Appeal in the appeal.
Were you aggrieved by this decree passed in the other partition suit of 2009? Were you aggrieved? Or this went in your favor?
Favor.
So therefore you were advised when you got this degree was passed that
Partly
unless you challenge the other one.
Partly favor. No, my lord. This degree and preferred an appeal by the Nuri.
Sorry, Mr. Ghosh.
But only one thing.
The present appeal has been
My lord,
preferred.
this suit will be the other is the
The present appeal has been preferred against an ex parte final degree of partition. Full stop. The delay in preferring the appeal is
Well, take up the
of about 2705
Well,
days.
take up the,
Full stop. Next para. Learned counsel for the petitioner submits that the petitioners were not aware of the ex parte decree impugned herein and as such could not prefer the appeal earlier. Full stop. It is submitted, comma, in consonance with paragraph number 8 of the application that the appellant's petitioners came to know of the ex parte dismissal in the month of December 2015. Full stop. Next para. However, comma, we find that even going by such statement, comma, the appeal was filed on August 10, 2016, comma, that is 8 months after the petitioner came to know, petitioner admittedly came to know of the ex parte decree. Full stop. There is no explanation whatsoever as regards the said 8 months delay. Full stop. More importantly, comma, it has been pleaded in paragraph number 8 of the application that the fact of the said ex parte decree was not informed by the then learned advocate for the appellants in the court below. Full stop. Next para. However, comma, learned counsel also hands over the copy of the judgment and decree, a copy of the judgment and decree passed in partition suit number 269 of 2009, comma, which is dated June 29, 2016. Full stop. Next para. Learned counsel for the appellant stroke petitioner, comma, in support of his contention that a liberal view has to be adopted by the court while deciding an application for condonation of delay, comma, cites a division bench judgment of this court in the matter of Alok Kumar Chattopadhyay versus such and such, reported at 2013 3 CHN bracket Cal 656, as well as another coordinate bench judgment passed in the matter of Sri Basudev Ghosh and others versus Sri Gopinath Ghosh and others within bracket FAT 74 of 2022, dated December 6, 2022. Full stop. Next para. Learned counsel appearing for the respondents 1 and 2, 1 to 4 opposes the said prayer and submits that no bona fides have been disclosed in the application. Full stop. Next para. There are certain factors which are required to be considered while deciding the present application. Full stop. It is not merely the span of delay which is to be considered, but also the conduct of the petitioners. Full stop. However, comma, in case of enormously long delays, comma, since valuable rights have been accrued in favor of the other party, comma, the court is required also to take into account such period. Full stop. Next para. In the present application, comma, however, comma, apart from no explanation being given for the 8 months as discussed above, comma, the petitioners cast the entire blame on the learned advocate appearing for the petitioners in the court below. Full stop. It is evident from the said admission that the petitioners were represented by an advocate and as such had appeared in the partition suit in which the impugned decree was passed. Full stop. Next para. However, comma, the laches of the petitioners is evident from the fact that even the preliminary decree in the suit was passed ex parte. Full stop. Next para. That apart, comma, there is no single averment in the application to indicate that the appellants were all along diligent and had been contacting their learned advocate in the court below. Full stop. The situation in a pending appeal before this court, comma, where the personal appearance of the client, the litigant, is not necessary, is different from that of the trial courts. Full stop. In the court of first instance, comma, there are several occasions when the litigant is required to appear personally, either for affirming affidavits or for filing applications and stroke or taking other consequential and incidental steps. Full stop. Next para. In the present case, comma, we do not find a single pleading or proof as to the appellants having ever contacted their learned advocate in the court below at any point of time to inquire about the whereabouts or status of the suit. Full stop. Next para. Thus, comma, although the courts are lenient in favor of applicants in condonation of delay applications, comma, such lenience is not extended as a matter of course to to litigants who are palpably negligent in their conduct. Full stop. In fact, comma, the malafidez of the appellants is also evident, comma, since the judgment and decree in partition suit number 269 of 2009, comma, another partition suit regarding the self-same property where the present appellants were also defendants, comma, was passed on June 29, 2016, comma, 2 months after which the present appeal has been filed. Full stop. Next para, we are informed, comma, on our query, comma, by the learned advocate for the petitioners that the petitioners have not preferred any appeal against the said judgment and decree passed in partition suit number 269 of 2009. Full stop. Next para, as such, comma, it is clear that the petitioners were not aggrieved by the said decree. Full stop. It is also clear from the chain of circumstances that the petitioners were obviously advised, comma, after the said decree was passed in partition suit number 269 of 2009, that unless an appeal is preferred against the present impugned decree, comma, their rights in terms of the other decree might be adversely affected, comma, which must have prompted the petitioners to prefer the present appeal. Full stop. Next para, be that as it may, comma, we do not find any explanation worth the name whatsoever to show that the petitioners were diligent with regard to the conduct of the litigation in the court below. Full stop. As such, comma, in the absence of any explanation for the delay, comma, we are unable to condone the huge delay of about 10 years in preferring the present appeal. Full stop. Accordingly, acha na aro duto line add kori. Insofar as the cited judgment in the case of Alok Kumar Chattopadhyay is concerned, comma, the factual situation there was different. Full stop. In the said case, comma, the coordinate bench had observed, comma, while deciding an application for restoration of a matter pending in this court, comma, that the petitioner therein was a resident of Purulia, which is situated at a long distance, and that he is an unemployed person and might not have knowledge about court procedures, and might have been supremely confident that his lawyer will look after his interest. Full stop. Next para. However, comma, there are several distinguishing features in the present case. Full stop. First, comma, as we observed above, comma, the role of a litigant while conducting a case in this court, comma, which does not require any day-to-day personal presence, is entirely different from that in an original civil suit pending in the trial in the court of first instance, where regular presence of the parties might be required. Full stop. Thus, comma, the present petitioners were utterly negligent inasmuch as they did not take any information about that suit during the huge period in between. Full stop. Secondly, comma, this is not a case, the present one is not a case where the litigation is pending in this court and the petitioner is a resident of a far off district. Full stop. The suit in question, comma, where the ex parte impugned decree was passed, comma, was very much within the residential district of the petitioners, and as such, comma, the grounds for condonation of delay in the cited judgment are not even applicable to the present petitioners. Full stop. Next para. Insofar as the other coordinate bench judgment in the matter of Nader Hussain Sheikh, in the matter of Basudev Ghosh and others supra is concerned, comma, in the said case, comma, the pandemic period intervened, full stop. The said the shelter of the said ground, however, is not available to the petitioner since the impugned decree was passed about 10 years prior to the preference of the appeal, that is in the year 2006. Full stop. Next para, that apart, the facts and circumstances of the said case are entirely different from the present, and as such, the ratio attributed by the court in the said case is not applicable herein. Full stop. In view of the above, we are not inclined to condone the delay in preferring the present appeal. Hence, Can 2 of 2023 is dismissed on contest without any orders to costs. Full stop. Consequentially, FAT 419 of 2016 is dismissed as time barred. Can 1 was allowed?
All other applications are allowed.
Are allowed. Is dismissed as time barred.
Only one will is the effect they have this head suit, head appeal, but not to go without taking into consideration the appeal mentioned in the second suit, filed and degreed. But not
How does that make a difference?
different when it is if it is dismissed, then the suit by pending, which is appeal is pending by the appellant, also been affected.
Yes, it will be affected due to your fault only.
No, this the appeal
That is what you have held, Mr. Ghosh. The we have held you on malafide because you waited for that. And when that degree was passed, you were advised to come here. Mr. Ghosh, you have passed our order. We won't explain our order. Please call on the next one.
This appeal is pending before the district.
Yes, who is appealing the next one?
Without taking into consideration them.
Yes. You have served on the other side. The appellant stroke petitioner shall serve copies of the applications on the respondents, indicating that the matter shall be listed next on April 28, 2025 under the same heading. Very well. On 5th May is the common list day. 6th May. On May 6, returnable letter. May 6, 2025, when an affidavit of service to that effect shall be filed by the appellants. Yes. Both sides.
Respondent number 6. 1 and 2. The service upon the private respondent is not complete, Lordship. May I take a not this week, Lordship?
Very well. Learned counsel for the appellant submits that service on the private respondents is not on all the. You are appearing for the private respondents?
Performer respondent. 3 to 1. I am appearing for 1 and 2 only.
On service.
1 and 2.
Oh, 3 to 5 were direct. Service on respondent numbers 3 to 5 has not yet been completed. So accordingly, on the prayer of learned counsel for the appellants, the matter is adjourned till April 16, 2025. Thank you. Yes.
In terms of your leave granted by yesterday, my lord.
You have amended the cost.
I have prepared the list, the name of the defendant. Due to lack of space of your lordship's copy, my lord, I prepared the list and made them as a pro forma respondent. There are 50 defendants.
No, but then you have to file a fresh memorandum incorporating the names. That is what we do here.
You will have to kindly.
We cannot. Otherwise, you cannot take.
It as a part of appeal.
You cannot. You cannot. That is entirely beyond the rules. You file a memo, new memo within a week. We'll give you a week. File that memo. We'll keep it in the list. File the no. That has to go to the department. How soon can you file a memo? You have to incorporate it and file a fresh memo, an amended memo, like an amended plaint.
Yes.
You have to file it in the department. Department has to accept that and send it to us.
Then it will take some time, my lord.
Learned counsel for the appellant hands over a list of the left out defendants in the trial court who are to be implemented as pro forma respondents. So it is submitted that due to dearth of space in the memorandum of appeal, those parties could not be, the names of those parties could not be incorporated in terms of the leave granted by this court. Full stop. Next para. Accordingly, on the oral prayer of the appellant, comma, we permit the amendment of the memorandum by incorporating the names of the omitted defendants as pro forma respondents in terms of the list handed over in court today, full stop. Sorry. The appellant shall file an amended memorandum of the appellant shall file amended memorandum of appeal incorporating the said added parties within a week from date. Full stop. Next para. Upon such amended memorandum being filed, comma, the office shall furnish a revised report in that regard. Full stop. The matter be listed next on April 28, 2025 under the same heading. Affidavit of service filed today be kept on record. You please just file two judges' copies of the memo. Take
Yes.
care of that.
By amending the,
By amending.
in the court or in the department?
In the department.
The
It
department.
will be done in the department.
Yes.
We are sending the file down. Done in the department. You do it immediately as soon as possible during this week. And after the office gives the revised report, we'll take it.
Matter to appear on
28th. Pass over both side.
No, both side name. No.
No.
Keep it on tomorrow, my lord.
Whenever you say. You dictate, we will write the order.
No. As your lordship desire.
Which item? This is item
4.
Item 4 টা not today করে দিন, কোনো order record করতে না, it's made not today. We have referred to that. We cannot return now. We have referred at length. Take out another copy from your client. Yes, next.
My lord,
Yes, Mr.
by
Goj.
virtue of my lord's last order, 1st of April, the lordship directed me.
My lord, in this matter, my lord, though it was my sister, Mr. Omnarayan Rai was in charge of this matter.
Justice Omnarayan Rai.
Justice.
You are guilty of contempt of court.
Lord, Justice Omnarayan Rai. And Jaita Kaunda was the advocate on
We'll
the
keep
court.
it after some time.
Lord, your lordship kindly keep it after some time. We shall contact and
Not sometime, after some time. You contact your client immediately. You must have the phone number.
my client, I shall try to.
We'll keep it after a week, Mr. Goj. After a week. What is this, Mr.
My lord, this
Goj?
is my lord, the pursuant to my lord's last direction. I have served my lord to everyone. Because your lordship keeps it as last chance since none one appeared.
Oh.
That is my lordship's last direction.
You are for the respondent. Affidavit of service filed by the respondents be kept on record. Full stop. Learned senior counsel appearing for the appellant submits that in view of the elevation of the previous of the erstwhile learned advocate conducting the matter for the appellant, comma, some time may be given to the him to ensure that the appellant is contacted and alternative arrangements are made for representation of the appellant before this court. Full stop. Accordingly, we adjourn the matter till we are giving you 2 weeks time. We adjourn the matter till April 23, 2025, when it will next be listed under the same heading. Yes.
I'm appearing for the response.
Yes, Samadhi, what is the matter?
The application for injunction.
What about this defect? The Vakalatnama bears same defect. You have filed look first. Very
For the application for injunction will be pending of the appeal.
No, you have this fresh Vakalatnama contains the name Sheikh Altaf Ali. Very well. Yes. What do you say, Mr. Samadhi? What is the matter?
For application.
Mr. Rai, you are for all the respondents?
No, I am for plaintiff respondent number 1 and 2.
Only for pending of the appeal of the injunction, therefore application injunction. It will not change the nature and character of the.
What is this? What was the decree against which the appeal has been?
Decree has been passed. My client is the defendant number 1 and 2. And they have been.
So you are not asking for any stay of the final degree being drawn up, only injunction.
The appeal is pending. It is pending. The last court.
Appeal is pending, but the final degree will be passed.
Final degree has not been passed without leave of the court.
So you are not asking for that order has been passed.
Yes.
That is what we are saying.
That is on 24th January.
So that order is already there. This is injunction. Yes, what do you say to the injunction, Mr. Rai?
As regard
Your prayer is only against the plaintiffs. Only against the plaintiffs. Mr. Rai will grant that.
para 10
Yes.
of the application, my lord, that
Yes.
applicant that on 15/5/2023, when the applicant went to the field under their possession, then the respondent with their main and agent threatened and the applicant could not enter. But my suit was that because of his repeated disturbance of my possession, we have filed the partition suit. Partition suit was preliminary degree declared the possession.
Mr. Rai, they have not, regarding possession, first of all, they have not asked for any injunction. So we were careful on that also. The prayer does not contain regarding anything regarding possession. Change of nature and character transferring to third party, that injunction will be granting.
Third party is.
And change of nature character also. Because if we change the nature character, it's a partition suit. And they have also said sought injunction from felling down valuable old trees.
Because
that forms a part of the property.
Yes, that is part of the property. I am in possession of that in respect of that.
You may be in possession, Mr. Rai. He is not actually in the prayer portion. He has virtually admitted that because he does not seek any prayer regarding protecting his possession. But if the valuable old trees have grown on the land, so if you sell those,
yes.
So we'll grant this injunction.
And in respect of status quo, in respect of their possession, my lord, because
possession you won't grant anything. Possession he's not praying. Possession will not touch possession. Only these nature character, transfer, and felling old trees. The present appeal arises out of a preliminary decree of partition. To sub next para, the appellants seek injunction restraining the respondents from changing the nature and character of the suit property and from transferring the properties and or from felling down old valuable trees. Pushed up next para. Upon hearing learned counsel for the appellants and the plaintiffs stroke respondents 1 and 2, comma, who are the contesting parties in the injunction application, comma, we are of the opinion that in the event the nature and character of the suit property is changed and or the valuable trees standing thereon are dealt with, comma, or the suit property is otherwise transferred in favor of third parties, comma, the appeal may be rendered infructuous. Accordingly, can 2 of 2023 is allowed on contest as against the respondent numbers, the plaintiff stroke respondent numbers 1 and 2 and ex parte against the others, thereby restraining the respondent numbers 1 and 2 from changing the nature and character of the suit property and stroke or from transferring the suit property and or alienating or encumbering the same in favor of third parties in any manner, as well as restraining the respondent numbers 1 and 2 from felling FELLING the valuable old trees standing on the suit property, comma, till disposal of the appeal. Pushed up. In view of the appearance of the respondent numbers 1 and 2 through their learned advocate, comma, service of notice of the appeal on the said respondents is dispensed with. Previously, directions were given for paper books and all.
Previously, direction
For paper books and all these things were given.
there was order dated 24th January 2021 at the time of admission of there.
অর্ডার থাকে না কেন
24th
আছে কি অর্ডার ডিরেকশন ফ্রিকশন দেওয়া হয়েছিল স্যার পেপার বুকে
Order is directed to the
কল ফর ইয়েস এভরিথিং ইজ দেয়ার ব্যাস এই পর্যন্তই থাকুক নো অর্ডার টু কস্ট প্রথমে এফিডেভিট সার্টিফিকেট কেপ্ট অন দিস মাচ the deductions are all there, Mr. Rai. Only you have recorded because you have already appeared. Thank you.
Well, I'm appearing for the Appellant petitioner.
You have to carry out corrections to the custody. You have done that.
Yes, I've been.
It's the office report
Yes, yes. May I find it?
as well as connected pending application in the event of the death of appellant number 8. No such correction has yet been carried out. What about appellant number 8?
It is allowed, my lord, only for the necessary correction to be carried. In course of this, it is my duty. I'll take steps, my lord.
What is the application for?
Now, these were application for injunction. Mr. Ritendra Managers on the other side, my lord, applicant 1 of 2020.
Appearing for the first time?
No, my lord. The order passed, my lord, on the last occasion. Your lordship find the order. It was passed by your lordship on the last occasion, where your lordship pleased to grant identity order of injunction, and they're paid for filing of affidavit. Pursuant to which, my lord, your lordship has.
Have they given you a copy of the affidavit?
No, affidavit has yet been filed, my lord. Today, my lord, don't.
Has Mr. Ritendra Banerjee and Srivasi Chatterjee gone to the cremation? But that's your resolution. If you go to the cremation, we will condone. Otherwise, if you're roaming around the corridors, then no. The mortal remains, we have ourselves gone and seen and also checked which advocates are there. So whatever you say, we'll make this absolute then. Come back tomorrow.
Only one thing, allow me to one
Yes,
extension, only for days extension to correct. Days extension.
Today you cannot. The advocate and record.
Why advocate today?
Today, very well. The no, we did not fix a time. Did we fix a time limit?
On the day.
The time for effecting necessary corrections to the memorandum of appeal and the application is extended till today. Puts up the learned advocate and record for the appellant shall carry out such corrections accordingly during the course of the day. Puts up next para. Since none appears for the respondents at the time of call, comma, let the matter stand adjourned for the day. সেইটাই 93 হয়েছে এখন তো 93 আচ্ছা এখন 93 158 টা কনসিডার করে দিয়েছো আজকের লিস্টে কি সেভ আছে yes Mr. Yes.
The last occasion, my lords.
That allocation of number of appeal and all were there. Now that is gone. You are for the respondent.
My lord, I am for the respondent. My respectful submission before your lordship is that.
Which respondent?
State.
5.
But my lord, I am on behalf of the state in the different appeal. My lord, I am relying upon the solemn order dated 24th March 2025 passed by this honorable court, my lord. Kindly come to paragraph number 6 of that solemn order, my lord.
But we get that. You have handed over?
I have not handed over. Kindly.
What does that solemn order say?
So, this order says that the court LCR has already been handed over, sent to this honorable court.
LCR has been sent to this court?
Trial court records have already been sent to this honorable court.
Now it's TCR. The Supreme Court deprecates lower court this time. So it's TCR now.
TCR. My lord.
Yes.
The trial court record has already been sent to this honorable court in connection with different appeals. But we have preferred different appeals. I am not in that appeal.
So
that item.
How is that relevant here? This is a stay application. Yes.
My lord, analogous judgment and decree has been passed by the learned court below. 29 appeals are there.
You are the claimant there in all these matters. Acha. Regarding the same area. Acha.
29 appeals have been preferred by the state respondents, and several appeals has been preferred by the corporation also.
Maybe, but insofar as this matter is concerned, we will pass the usual order. They will be stay subject to their depositing the amount. Only that stay, we are taking up that stay. We are not taking up the hearing of the appeal. If we took up the hearing of the appeal, then we have to take up all matter. Thank God this appeal is not ready as yet.
My respectful submission, my lord. Yes. I am led by Mr. Sushobhan Sengupta, my lord.
Mr. Shuman Sengupta?
Sushobhan Sengupta.
My lord.
My lord, kindly.
What happened to him?
My lord, he has some personal difficulties, my lord.
He's in court or out of court?
It's not in court, my lord. My lord, kindly adjourn this matter at least for 7 days, my lord.
Why? Why adjourn? We'll dispose of the stay application and the appeal will be heard much later than that.
As your lordship may deem fit.
But don't enter Mr. Sushovan Sengupta's name.
No.
Don't have to show that, but don't write that.
No.
Because if he's not in court.
May I record my name?
Yes, you're happy. Why shouldn't you?
One thing, may I?
We'll just check up. We'll just কোথায় আছে রিপোর্টটা এখানে মেমোতে থাকবে নতুন মেমোতে আচ্ছা এখন কোড ফিটা চেঞ্জ হয়ে গেছে সেটা বলছে ও না আমরা কনভার্ট করছি ঠিক আছে আমি করে দিচ্ছি There's a deficit code fee, Mr. Pale. 6630 rupees. আগে মেমোতে ছিল Oh, yes, because we have converted it to an appeal. Previously, it was the writ, the court fee regarding writ. Mr. Roy has understood. So you'll have to now put in the deficit court fees as per an appeal. Right. Do that and come back day after tomorrow. Or next week so that Mr. Sushovan Sengupta can also, and he will be relieved. You have difficulty. Which date?
17.
You all of you agree on a date and give us the date, we'll put it on there. All of you first agree.
বলবেন বলুন আপনাদের যা ইচ্ছে আমি সবসময় আছি
You're checking your diary. You have to check the diary of Mr. Sengupta. No, please check your diary. এই কমেন্ট গুলো কমাতে হবে বেশি কথা বলছে বলছে
21st করবেন
Those pages are blank. Where are you looking? Those pages are blank. Look at the filled up pages.
No, my lord, no, my lord.
We can see from here.
My lord, this junior stage, my lord, I have to assist my learning.
You first of all, you are quite competent, even if you are a junior, and the number of entries in your diary does not mean that you are a good lawyer. Not necessarily. May mean that, may not mean that also. We are not bothered with that. But the pages which you had opened were blank. That's why you were pointing out that.
No, my lord.
Give us a date.
21st.
Very well. We'll keep it on 21st. You have a difficulty. That has 158 has been.
Called over phone, but department they say because it has not been mentioned that memorandum of appeal, formal memorandum of appeal which I have filed has not been tagged with that 93 matter. Therefore, my lord, they said to file a fresh formal memorandum of appeal. They have or clarified it by lordship that it will be tagged with that old matter because they have given a new number. That appeal which we have filed, formal appeal.
Very well. We find that the memorandum of appeal which has been filed as per our direction by the appellants, upon conversion of the initial writ petition, was initially numbered as FAT 158 of 2025, however, in view of a subsequent order, let the said memorandum be treated to be filed in connection with FAT 93 of 2023 and be tagged with the file of FAT 93 of 2023. The appellants shall put in the deficit court fees within a week from date. The application shall be listed next under the same heading on April 21, 2025. Affidavit of service filed today be kept on. Thank you. Please give all of your names. You give your name. You give your name.
But I have given my name, my lord.
Give another respondent.
Mr. Rahman has apparently gone to see justice,
Morning, item number 5, he was there.
but now he has gone to the crematorium. That is a presumption today. None appears for the appellant. Full stop. Let the matter stand adjourned for the day. এটা কোন ম্যাটারে দিল বলুন তো আগেরটাই নাকি নাম্বারটা দেখি 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 হ্যাঁ হ্যাঁ এটা আগেরটা আগে ও দেখি 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 প্রিভিয়াস অর্ডার আছে অর্ডার হবে না লাস্ট চান্স দিয়েছে আজ তাহলে ডিসমিস করতে হবে সকাল থেকে রেজলিউশন গুলো হ্যাঁ যারা দেখতে যাবে তাদের কি আর আমরা টাইম রিফিউজ করবো মিস্টার রায় হ্যাজ গন এন্ড কাম ব্যাক
Mr. Rai.
না সবাই আছে যারা রেগুলার সবাই আছে সবাই আছে এই মিস্টার রায় ওই মিস্টার রায় মিস্টার ঘোষ
No, this is for the supplementary evidence for the explanation of the. And
No.
Procedural was done. Yeah.
you have done yes supplementary affidavit, this is delay
Delay for explanation of delay for 66
what is the
days.
period 66
Yes. My lord, this is a suit for partition.
yes
which is-
there was no explanation in the main application
According to it is. My lord, what happened, my lord, is a suit for.
you have served a copy on the other side
Yes,
did you
yes,
directly
evidence service, my lord.
good service
Yes, yes.
yes the appeal arises out of what Mr. Rai
Partition suit.
final dismissal
Preliminary degree has been rejected. In respect of A schedule property, it was held that the plaintiff has exclusive ownership. But the A schedule property is the joint property and B schedule property belongs to the plaintiff exclusively. We have filed a counterclaim in the suit where we have challenged that both the schedule property and the age value property, so partition degree should be passed in both the
the counterclaim what about the counterclaim
counterclaim dismissed.
so two appeals then
Yes, initially one appeal was filed.
this is that second appeal
This is the second appeal. When that is why, my lord, this explanation was granted at the time of
that explanation has been given in this
in this supplementary. That
no financial hardship is the ground
it is very much difficult to say something which is not true. I can say,
it is very difficult to say something which is true
Oh, my lord.
it is not
Section
at all
of the
difficult to say
restoration-
something which is
My lord, so much section of restoration. These are the two applications.
these are storytelling classes nothing is but the story has to be credible
Yes, well, that is the only thing. Something.
Very well. The affidavit of service filed today be kept on record. Full stop. We find that despite service not adverse order.
Yes, I forget that.
We will keep on the affidavit of service filed today be kept on record. Full stop. Have you given a copy of the supplementary affidavit
Yes,
also?
yes, that is the video service.
Oh, acha. The supplement.
Passed by your
The
lordship.
supplementary affidavit filed by the appellants is also kept on record. Full stop. Since none appears for the respondents at the time of call, comma, let the matter stand adjourned for the day.
Yes, sir.
Yes. Yes, Mr. Dr. What is
Caveat of appeal arising out of preliminary decree.
come prepared tomorrow again?
There
None
was-
appears. Yes.
There was a direction for service. I have served on the other non-caveator respondent.
Good service affected.
My lord,
Just check up if একটু দাঁড়ান হ্যাঁ
these are the
what are the endorsements?
one has received all residing at the same address.
Ah.
One has received rest. No such person in this address. But this is the address given by them in the court below.
They were co-plaintiffs.
They were they were co-defendants. They were co-plaintiffs.
Co-plaintiffs,
They were
yes.
co-plaintiffs.
No, may not be. This is a partition suit.
The partition.
No, we will check up with it.
This address was given by the caveator plaintiff.
Caveat plaintiff for himself.
No, for others who were sought to be added subsequently. But initially he had filed against only me.
First, tell us this is against what?
Preliminary decree. But against he had filed only me, saying that the property had only 2 legal heirs.
Right.
We indicate that no, there are others also. We indicate the names. Thereafter, he comes up
Included them in the suit.
Yes, included them. He finds out their residences, their addresses.
In the suit itself.
Yes, in the suit.
So you have served at the address as disclosed in the plate.
Yes, in the plate.
Did those people contest?
No, apart from one, none of them had appeared in the suit. The one who has received had appeared in the suit. And the caveat plaintiff.
Have filed those, will just record an order. The affidavit of service filed today along with the connected envelopes, comma, which have returned from the respective respondents, comma, be kept on record. Full stop. It transpires that barring one of the said respondents, comma, the others, comma, apart from respondent number 1, comma, have not received the copies. Full stop. The endorsements on the envelopes indicate that no such persons reside at the said address. So, however, it is pointed out by the counsel for the appellant that the copies were sent at the address which were disclosed in the cause title of the plaint in the suit from which the present appeal arises. Full stop. Moreover, the unserved respondents had not contested in the code below. Full stop. Accordingly, further service of notice on the unserved respondents is dispensed with. Full stop. However, since none appears for the plaintiff respondent number 1 within bracket caveator to oppose the application today, let the same stand adjourned for the day. So you have taken care of this service. Tomorrow we'll just take up the matter.
Caveator had appeared on the last.
Yes, he had. Mr. Pradyut Nandi appeared.
Time for the respondent.
Respond. What should you do?
But as per lordship direction, earlier direction, no copy has been served upon.
No copy has been served?
Yes, my.
You are for which respondent? There are several respondents.
Yes, my lord.
You are for which respondent?
All respondent, my lord.
All respondents? No, cannot. You must be for 1 and 2 who are the plaintiffs in the code below. The others are different. Others are pro forma response.
On behalf of the respondent.
This appeal arises out of what sort of a suit? Preliminary degree of partition.
Partition suit, my lord.
And
And
all have
final degree has been passed, my lord. And the allegation is that two appellant has been expired and no substitute has been.
Oh.
As such,
Very well, since they have not served any copy, we will direct them to serve a copy. Learned counsel appearing for the respondent numbers 1 and 2. You are for Upay Pradhan and his wife. You are for, what are the name? Uday Pradhan, sorry. Uday Pradhan and his wife.
Yes,
Learned counsel appearing for the respondent numbers 1 and 2 submits that no copy of the applications have been served on his clients despite previous direction of the court. Full stop. Since none appears for the appellants today, comma, let the matter stand adjourned for the day. Full stop. It is expected that
let it on Monday, my lord.
very well. Is adjourned. Monday is a holiday. Is adjourned till April 16, 2025. The next April 16, 2025. Full stop. It is expected that copies of the applications shall be served on the respondents directly and or through their learned advocate in the meantime. Next. Thank you. Now, please give your appearance, sir. Just give your appearance. For respondent numbers 1 and 2.
I have filed the power, my lord.
You don't want your fees for this appearance? Call on the next one.
This is my application.
Why are you laughing? Both sides are not here.
No, well, both sides are here, but well, I'll be seeking
Why?
some time for filing my reply. It's my application for
Opposition you have filed?
Yes, well, long back. We are in
Second
default.
extension being sort of, I'm not standing in the way.
There is no
You have
stay.
done sufficient to indicate whatever you had. Why?
But
If you are an authority, we won't grant it.
I do not have any excuse to give for this delay.
You have too many litigations in High Court. We have been seeing from our practice days.
Maybe.
So that's a sufficient excuse. How long? 1 week?
2 weeks more difficult.
Why you are based here in Calcutta?
Yes, we are
Then
based here. If it could be 2 weeks more.
your learned junior is trying to make as so sad a face as possible. He's trying to evoke all his emotions. Anyway, we are extending it. On the pair of the appellant, comma, the time for filing reply is extended for a fortnight from date. The matter shall next be listed on April 23, 2020, April 28, 2025. Grateful. Thanks. Abdul. आपने की फाइल लाई नहीं नहीं ओह फाइन यस
Item number 20.
Where is Mr. Falguni Bandyopadhyay?
He is the main contesting. Will also
He has not come to court.
tomorrow.
They will take it up tomorrow, Mr. Mathur. Since none appears for the respondent number 1 at the time of call, let them attest and adjourn for the day. Please give your name, sir.
Yes. Only 2 and 3.
সবকটা নেমে যেতে পারি হ্যাঁ সব নেমে যেতে পারি সমাজ ব্যাংকের নাম করে এরা তো এসছে
Item number 21.
কেউ যায়নি সমাজে ফাল্গুনি যাবে সমাজ ব্যাংকে তুই ফাল্গুনি খুব ভালো করে চিনো
I am appearing for the petition. I am paying for not today.
refused. What is the matter? We are refusing that prayer. What is the matter about?
I am led by Mr. Shivaji Kumar Das. I am.
You are led by Mr. Use the microphone.
My lord, I am led by Mr. Shivaji Kumar Das. My lord, he is
Mr. Shivaji Kumar, how long are you practicing?
just 6 months. My lord.
6 months is sufficient. What is your name?
My lord, Aniket Karar.
Aniket?
Karar.
Karar. Mr. Karar, what is the matter about? You have to tell us that.
My lord, I am.
There's a rule in this court. If you don't tell what the matter is about, we dismiss it for default.
My lord, I am kind.
We are passing it over. Go through our brief and address the court. You will get 5 minutes time. Just address us at least about what is the matter about. একটা ফাইল ওনাকে দিয়ে দিন একটা কপি ওনাকে দিয়ে দিন go through the application and just you have to tell us what is the application about. We will take it up after 1 or 2 matters. Yes. Pass over. Next.
I am for the petitioner. Pursuant to Justice last direction, Lord, I have served the copy of the Section 5 application.
Today, should you take up because the other side
The
file your affidavit
service, endorsement says that the
insufficient.
is left without instruction, but she is not appearing in 125 proceedings, dropped. She is not contesting other proceedings. Her evidence was closed, not offered for cross-examination in the suit for guardianship. Lord.
True, but
Today, your lordship may not take up. But
no, but you have to then effect substituted service.
can it be this address? She is not filed.
You have to ascertain the current
that same address.
Oh, this arises from what?
Arises from the order passed under Section 25 of the Guardians and Wards Act, refusing.
It was her application.
It was my application. It was rejected. She contested by filing that WS, but she did not offer for cross-examination. And
She contested at that address only.
At that address only. And that is the written statement.
So we'll take the affidavit of service. No, affidavit of service. Affidavit of service.
So this is the affidavit service, and this is her written objection.
Respondent number 2. Why 2 respondents?
Minor girl, represented by the mother.
It transpires from the affidavit of service filed today, comma, which is kept on record, comma, that the envelope sent to the respondents has returned. There is no endorsement as such.
The date instruction, that is a tick mark. Tick mark, my lord.
Has returned.
Left without instruction. Sent to RTS means return to sender. The back of the envelope.
Oh, right. Thank you. With the endorsement, addressee left without instructions. Pushap, however, comma, learned counsel for the petitioner submits that the respondents had all along had appeared in the trial court at the self-same address and had filed
Written objection.
respondents na করে respondent 1 করে respondent 1 had appeared যা বললাম and had filed her written statement written objection full stop next para. It is also pointed out that the respondent 1 has since been avoiding appearance in the court below as well as other proceedings, comma, including a proceeding under section 125 of the Code of Criminal Procedure. Full stop next para. In such view of the matter, comma, we deem that the respondent number 1 is deliberately avoiding service, full stop, since the respondent number 2 is the minor daughter of the parties, comma, further service on the said respondent is dispensed with. আচ্ছা তাহলে since বলে যেটা লাস্ট বললাম সেটা কেটে দিন since last sentence. The next para, however, comma, since none appears for the respondents at the time of call, comma, as a last chance to the respondents to appear and contest the matter, the same is adjourned for the day. You ready? Thank you. এটা not today করে দিন। এটা কোনো রেকর্ড করতে হবে না। 23 টা not today। ওই ওনারটা কল করুন। Let the file come to us. Yes. What is this? Section 5 application. That is scan 2. And there is an injunction application also. Do you have any idea this appeal is arising out of what? You have done sufficiently well. Very well. We are satisfied. Thank you, Mr. Karan. If you do like this, we hope you will be doing matters very soon. And we expect you to do matters very soon. Mr. Karar, learned advocate for the appellants, submits that the present applications have been filed respectively for condonation of delay in preferring the appeal as well as for injunction. Full stop. The appellants, let us just check up. Oh, section 5 allow all. The appellant shall serve copies of the applications on the respondents, indicating that the matters shall next be listed under the same heading on April 28, 2025, when an affidavit of service to that effect shall be filed by the appellants. 28th April, serve immediately, affidavit of service on that day. Yes.
This is my application. The other side is not here because
who is appearing for the other side?
Mr. Shoptoshi Dotto was appearing for the other side.
We must have a mechanism in place to ensure who have gone to the crematorium, who had gone downstairs, you have seen personally. But
yes. Problem is this, I do not know, on the other day he submitted that he is entered appearance on behalf of the respondents. And your lordship dispensed with service of notice of appeal. Now, I do not know whether he has at all filed the Vakalatnama or not. Otherwise, I will be in difficulties.
Yes,
again,
absolute difficulty. No, then
I do not know whether any endorsement, official endorsement with regard to the Vakalatnama. I have not gone through the.
You just check up.
This is with regard to the visitation of the
visitation,
child.
yes, yes.
After the order passed by your lordship, there were 4 Saturdays intervened. During these 4 Saturdays, only in once he came at time at 5 o'clock, and on 2 occasions she did not turn up, and on the other occasions, well, she came at 6:30.
What was the time given by us?
5 to 7.
Let Mr. Dotto
No
come.
affidavit has also been filed.
We don't find any Vakalatnama tagged with the file, but we don't know whether it's in the department.
Kindly direct the department to tag the
But you have some doubt.
file.
You have some doubt in that figure.
Yes, my lord, I have doubt.
Then it has to go down for a day or two.
Well, in any event, well, I think well, tomorrow your lordship.
Tomorrow in any yes.
It will be again on
Next
Wednesday.
Wednesday. Yes. Very well. So we'll keep it the Monday after that because the office requires some time.
My lord. 21st, well, it will be
21st, yes. None appears for the respondent at the time of call, although the appellant is represented through counsel. Full stop. Next para. The office is directed to ascertain as to whether Vakalatnama has been filed on behalf of the respondent and tag the said Vakalatnama, comma, if so filed, comma, with the main file. Full stop. Such exercise shall be completed by April 17, 2025. Full stop. The matter shall next be listed. The application shall next be listed under the same heading on April 21, 2025. Thank you. এটা সব সিভিল বলে খাওয়া পার্থ সব সিভিল করেছে স্যার মানে আমাদের শেখাতে পারে ভালো খুব ভালো Yes, there is a delay of 36 days.
Your Lordship, we got the decree drawn up on 5/4/25 and we serviced on 7/4/25. The item is still on dispatch.
But decree, you have not yet got the decree.
We have got, it was delayed by the lower courts. So it was 5/4.
That is the cause of the delay you are saying. No, have you? Did you direct it to serve a copy of this application on the other side?
Yes, I did it on 7/4/25. I have submitted, but it still hasn't reached it yet. It still hasn't reached the other.
You have not yet got a track report showing service. So should we keep it on when? Tell us. Short date. Today we are on 9th. We'll keep it on 16th, next Wednesday. Very well. On the prayer of the appellant, comma, since service has not yet been complete on the respondent, comma, let the matter stand adjourned till April 16, 2025. There are other defects also. Please check up the file later on. ঠিক আছে Who is appearing for the other side?
But in the lordship, kindly, this is my lord, today can 2 will be considered. Now, my lord, we have served. Now, my lord, when the initial.
Mr. Bhattacharya is there.
26.
Oh, saved. What is can 2? Condonation?
Can 2, my lord, is for modification of your lordship's order dated 10th February 2025.
What was the order?
My lord, order was, my lord, to pay. This is money suit.
Oh, money suit.
Money suit. Lordship, my lord, had rightly passed, deposit the entire decretal amount, and my lord, stay.
What did you do? Did not deposit?
No, my lord, we could not, my lord.
What is the modification? You are asking for an extension of the time?
No, my lord, we have prepared a demand draft of, my lord. We have explained our, my lord, financial position. We could, my lord, gather 4 lakh rupees, my lord, out of, my lord, 8,71,276.
Where have you explained? Let us see.
Yes. Kindly comes to, my lord, page 6, my lord. Para 11 onwards. Your petition.
Have you annexed any document? You are now selling better leaves and daily labor. What about the brickfield? Any document to show that brickfield has been closed or something like?
What happened, Millard? This was an agreement between my client and the Millard, my learned friend's client. Was that that they have handed over their brick field to me, and I will, my lord, manufacture bricks, and my lord, a portion of the, my lord, I will sell them, a portion will of the money will go to them. Now, my lord, that was their allegation, that the allegation that I did not give them the proceeds of the sale. Now, my lord, for that, my lord, they approached on two parallel forum. One is a criminal forum where, my lord, a long trial, my lord, it's still pending. I was arrested. Bail has been granted. I am out of bail. Now, my lord, and this money suit, my lord, which has been decreed. Now, my lord, 12 and 13, my lord, I cannot, my lord, he's working as a daily labor, my lord. If your lordship wants to, my lord, he will be present before your lordship. If your lordship wants to see, my lord, and
Why should you see?
Draft we have already prepared. We have taken loan from son-in-law and other relatives of 4 lakh rupees, and our draft, my lord, to that extent is also ready, my lord. This is the thing.
Yes, Mr. Bhattacharya, what do you say?
My lord, since 2017, my lord, at that point of time, my lord, I have also invested some more amounts, my lord.
Yes,
My lord,
but
after
he's
considerable-
acting as a daily labor,
My lord,
working as a
now
daily
they are,
labor.
he's claiming to be a, there is no document.
Daily labor.
What
My
document
lord,
will you show?
admittedly, he had a business at that point of time, my lord.
He did, but he
2000
says
the
huge
decree of
financial losses and
2017, my lord.
had to contest several litigations, both which lost all his savings. You have not stated that the brickfield business is no longer there. Oh, totally out of business. Sorry, you have said, yes. It's totally out of business means the brickfield is still there. You are still in control of it.
My lord, that I have to take instruction, my lord.
Not at
My lord,
all.
yesterday evening, my lord, just I have received this, my lord, documents, my lord, entire documents, my lord. I have
You
even
can
not-
file an opposition to this if you want.
My lord,
Because there are
also
certain
the-
facts stated.
My lord,
We are otherwise inclined, we are making it clear, we are otherwise inclined if these financial stringencies, we have that discussion to,
my lord, that is your lordship's
but
discretion.
we may exercise that. But unless you point out something which is gross, is
My lord,
suppressing something,
my lord, that I have
we'll
to-
grant you
1 week time. my lord.
1 week time.
1 week
Thank you. That is fair enough.
See the impugned judgment. It has been recorded in the impugned judgment that now it is in their possession.
Let him take instruction.
Yes,
I will direct you to file affidavit in opposition, if any, within a week.
my lord.
If you have to say anything, do that
My lord, but money execution case is proceeding.
My lord,
within 2 weeks. Nothing will happen. The
1 week, only 1
Uh,
week. Next week.
no, we'll have to give them 3 days to file that reply. Can 2 of 2025 is an application for modification of our order dated February 10, 2025, whereby we had granted stay of operation of a money decree, of the impugned money decree, subject to deposit of the decretal amount. Push up. Learned counsel appearing for the petitioner, appellant stroke petitioner submits that the appellant is not in a position to pay to deposit such amount due to extreme financial hardship. First up, it is contended that the petitioner previously used to handle a brick field but is now totally out of business due to huge financial losses from the said business and several litigations. First up, due to such extreme financial duress, comma, it is submitted that the petitioner is now passing his days by selling betel leaves, BETEL, leaves in the market, and also by working as daily labor on others, এসের পরে apostrophe lands. First up, next para. Accordingly, the petitioner seeks to uh, uh, seeks, comma, as a condition of the stay, comma, to deposit a demand draft of rupees 4 lakh, which is less than the decretal amount. So next para, learned counsel appearing for the respondent seeks some time to take instruction and use an affidavit in opposition, comma, if required. Full stop. Accordingly, the respondent is directed to file affidavit in opposition to the application, comma, if any, within a week from date. Reply, if any, shall be filed within a week there, within 3 days thereafter. The matter shall next be within a week thereafter. Within a week thereafter, the matter shall next be listed on April 28, 2025. Mr. Bhattacharya, please don't do anything in the execution case in these 2 weeks. You instruct your clients. We are not passing any order on that.
Order of croaking has already been passed of our property.
Then whatever had to be done has been done already.
No, the landed property, my lord, it has been sent for valuation.
It won't be sold in a fortnight.
Yes.
Item number 27.
I'm appealing for
Yes,
the appellant.
Paternity, what is the matter?
Lord, I'm appealing for the appellant.
Other side is not there, so
The caveat is for the first time.
let us. You have served on the caveat.
Caveat.
Tolabon of rupees 5 put
Lord,
in during the course of the day.
Now, my lord, only the appeal arises out of an order where, my lord, my suit for specific
No,
performance.
should he take up the matter because the caveat is there, and today you have a resolution. Affidavit of service filed to be kept on record. However, none appears for the respondents at the time of call. Full stop. Accordingly, let the matter stand adjourned for the day. The appellant shall put in Tolobana of rupees 5.
The service because for all he has received, for all of the respondents.
আচ্ছা তাহলে ওটা
That can be, my lord, dispensed with.
no caveat has been lodged on behalf of all.
Yes.
You have checked up.
Yes, my lord.
আচ্ছা তাহলে লাস্ট সেন্টেন্সটা কেটে দিয়ে তলবনাটা তার বদলে learned counsel for the appellant submits that the learned advocate lodging the learned advocate appearing for the respondents has entered appearance through lodging a caveat on behalf of all the respondents. Full stop. Accordingly, the no further service is required to be effected both as regards the application and the appeal on the respondents. Full stop. Accordingly, we dispense with the requirement of to file Tolobana of rupees 5 on the part of the appellants. Adjourn for the day, tomorrow come.
Item number 28.
Lord, I am for the petition.
There is any caveat?
Lord, not caveat, but there was direction for service. Lord, I have effected service upon the opposite party.
Wait for a day then. Today you have a resolution, so. Affidavit of service filed to be kept on record since none appears for the respondents at the time of call. Respondent at the time of call. Let the matter stand adjourned for the day. Yes. Not today. Order record করতে হবে। না থাকলে order record। দিনের শেষে 100টা not today order record।
Item number 30.
Well, I am for the respondent number 1 led by Mr. Boydurju Ghoshal.
What is the matter about?
Uh,
You are not even supposed to know or be heard.
I'm no
Order for
this
stage.
matter, Lordship.
Not only that, at the order for stage of a second appeal, none appears for the appellant at the time of call, although the respondent is represented through counsel. First of let the matter stand adjourned for the day. Please give your name. Order for to right of hearing.
Item number 31.
First time or someone is appearing.
First time, my lord, order 41, there's a defect with regard to DCF, my lord. May I just pay and come back, my lord?
Wait. The appellant shall deposit the deficit court fees during the course. Appellants shall deposit the deficit court fees during the course of the day. Full stop. Let the matter stand adjourned till tomorrow.
Very good.
Thank you. You just produce a receipt tomorrow when you take up because we won't have time for the
Actually uploaded in the case status, sir.
Produce that. Now no receipt is given.
The Vokalatnama, sir, reflected here.
Oh, just take a printout and
Item number 32.
both sides. Yes.
Right of audience, my lord, at this stage, order 41.
Second appeal. Yes. Yes, Mr. Maiti.
There is a condonation delay. 620.
You have to cure the defects. Have you done it?
Yes. Only the name of the
One
judges.
technical objection, section 5, it has to go before single bench.
But we are allowing the section 5 right now. What is the
No,
delay?
Only defect, my lord, the name of the judges I have corrected. দিদিস কালকে দিদি সব স্টে অ্যাপ্লিকেশন সেকশন 5 সব দেওয়া হয়েছে।
They've not even gone through the section 5. You're confident on the about the court. No, what is the delay? What is the delay, Mr. Mighty? And what is the if the explanation is against any advocate, then we'll not allow it.
No, medical ground
Of
of the client.
what is the span of the delay approximately?
625 days.
625. Should have gone through the section 10. What was the nature of illness, Mr. Mighty?
I've annexed the document.
Tell us.
That is my lord. The
Unless it's unpronounceable, you have to tell us.
That is stated, my lord. Apart from that, I annexed the document, medical document.
No, 625 days. What is the nature of illness? We are also curious.
That is stated in paragraph
Right.
3.
Right. This is perhaps, my lord, since the execution has matured to the some extent, my lord. That's why, my lord.
No, no, but
Paragraph 2 and 3.
rest for 1 month in January 2024. So when was the appeal filed?
Appeal
4th February. But appeal was filed on
without condemnation delay, I will file thereafter.
yes, without condemnation, no difficulty. No, appeal was filed when? Appeal was filed on 18th of September 2024.
Yes, decree of
1 month's test was given to you in January, and you file in September.
That is happened, my lord.
No, the period of delay is not important, but the reason has to be there.
Reason, my lord, I have stated, my lord, that's
All pertain to January 2024. You have filed the appeal in September 2024.
This is the disease, my lord, chronic disease, my lord, suffering long back.
Chronic disease,
Not only the chronic
breathing trouble, asthma.
long back.
Please, no blood pressure, no asthma, no constipation in this court. All of us have shades of that, at least during matters.
What I have instructed, I have submitted before lordships. I cannot improve otherwise.
Make out a better story, Mr. Maitha. We are not very happy to dismiss Section 5 applications.
I cannot say that.
But you have annexed a document of January 2024. What about the explanation for the 8 months?
That has been collected by my client.
That depends on your creativity, not your client's. We'll permit you to file a supplementary evidence, Mr. Maitha. If you can't create a story, take help of Mr. Bhattacharya. Come back, you file a supplementary affidavit within a week. Your client stays where? Which district?
This is Birbhum.
Birbhum. So 2 weeks time.
So the execution case is proceeding.
It will go on. You cannot have it both ways.
That's why
It's better than dismissal of the Section 5 right now. Otherwise, we'd have to dismiss. You have annexed a prescription of January 2024.
That documents have been collected or received from my client. That is annexed.
You see your explanation?
Paragraph 2 and 3.
Yes. Just read out your explanation, Mr. Maiti. Paragraph 2 and 3 read out.
Paragraph 2, the applicant could contract with the learned advocate for certified copy of judgment in the month of August 2023. Due to the reason of the appellant was an ill and accordingly delay of
2 contains nothing. Read out 3.
The explanation has been 270 days delay. That has been done. On that, the certified copy of judgment decree delivered on
Due to the reason applicant was ill,
Yes.
and accordingly delay of 270 days has been held.
Could not contact with the client.
What is the nature of illness? Not even stated.
That illness, my lord, that has been annexed the document.
Acha, very well.
medical document.
Come to that illness at paragraph 3.
The paragraph is that the appellant states that the appellant is in
Applicant is an asthmatic patient who frequently suffers from asthmatic attack, compelled to remain confined at home. To substantiate statement, some doctor's prescription.
What have been received, that have been stated. I cannot improve for myself. That is improved for that has been stated.
Then we have to dismiss. No sufficient ground. No.
Decree of 2022 cannot be 270 days. That
আমি কি তৈরি করবো না যা পেয়েছি সেটা করেছি
DHMS হোমিওপ্যাথি নাকি না হোমিওপ্যাথি ট্রিটমেন্ট হয়তো করায় ক্রনিক অ্যাজমা হোমিওপ্যাথি অনেকেই করে কিন্তু অ্যাজমার জন্য অ্যাপিল ফাইল করতে পারবে না 672 ডেজ
Could not contact with the learned advocate. That has been certified copy. Could not be-
672 days, you are advised 1 month's rest.
That is, that has been instruction which is.
We'll come back after recess. Let us see if you can improve. If you can improve. If you can convince us rather. We'll continue after recess.
Or your lordships,
No, we'll continue after recess.
Or lordships, my lord, or lords giving liberty to I can construct my lord the land.
No, don't have to make out a story. You come back after recess. If this is sufficient, we'll allow. Otherwise, we'll dismiss. We'll take up from this matter after 2. Yes, Mr. One.
The outset, my lord, at the outset, my lord, beg to submit, my lord. Required to be a modification to this.
What modification?
Delay. I beg to apply 2 days times so that my lord I can be.
Now, counsel for the appellant seeks 2 days accommodation and the leave to file a supplementary affidavit to the application for condonation of delay. Full stop, such leave is granted. Full stop, an advance copy of the supplementary affidavit shall be handed over to the learned advocate on record for the respondent. In the meantime, full stop, the supplementary affidavit shall be filed on April 16, 2025, when the matter shall next be listed under the same heading.
Supplementary.
क्यों नहीं है क्यों नहीं যখন not today করে দিন just order record করতে হবে
What did I appear for the appellate?
Yes.
My lord has had occasion to hear the matter in its periphery on a previous occasion.
There's a
defect.
Yes, what is the defect?
My lord will see, I believe there is a report. It should be marked differently. It's a RERA appeal. It
Oh,
has been
that.
marked, since it's a second appeal passed on the basis of the against the order passed by the appellate authority. So we marked it as SAT. It should be FMAT RERA. I think so. That's what the report says, subject to
Yes.
correction.
Because I had moved an appeal. There is an order of a division bench which sets down how it should be numbered.
What is the numbered as FMT data?
So
That is Justice Tandon's division bench, Mr.
yes,
Chaudhary.
yes, yes.
Justice Tandon's division bench itself took up to others SMATs from RERA, similar. SMAT 4 of 2024 probably and 5. So we checked up this thing. In that, the appeal has been entertained as SMAT, heard at length, and judgment was reserved by Justice Tandon. We don't know after that what happened. It has.
I mean, I have a Milord.
So this is SMAT. It should be SMAT because we are giving our reasons, Mr. Bose and Mr.
I have, on this slight business
Yes,
and
exactly.
nomenclature, there is no need.
So it's not SAT because this is not against a decree.
Yes.
SMAT because the premise of this FMAT thing against remand orders, we prefer FMATs. Original injunction applications in a suit against that, obviously, first miscellaneous appeal, it is the miscellaneous appeal which is being filed for the first time. But why FMAT against remand order? Because trial court passed a decree. It was a first appeal at the first instance. So that was a regular appeal because it was against a decree. For the first time, an order is being passed by the appellate court if it's a remand order. So it's a first miscellaneous appeal because it's for the first time it's being tendered as a miscellaneous appeal. In the RERA cases, in both the instances, both the courts below are passing orders,
Yes.
not decrees. So if it's a decree, principle is decree, regular appeal, non-decree. So therefore, that was the first miscellaneous appeal. This is the second miscellaneous appeal. So this has to be tendered as a second miscellaneous appeal. We'll grant you liberty, Mr. Bose, to carry out the necessary correction in this.
There is, I think, another small correction to be carried out. I think the name of the chairperson has not been mentioned.
No, that has to be introduced.
It has to be done. We shall do so.
Milord,
Yes, Mr. Chaudhary, you were saying something.
yes, Milord, I am in some confusion now. Milord, I am doing another similar matter before the bench taking up, Milord, second appeals for hearing. Learned single judge taking up hearings of second appeal. So therefore, that would not be correct. I would have to bring the matter here for hearing.
No, this is admission hearing. Admission hearing is done by the division
Yes,
bench.
but would that Milord apply to, as Milord has said, would
It has been admitted already.
that has been admitted?
That his other appeal has been admitted. This
That will be heard by the learned single judge.
After admission, it will be
After
heard.
admission, it goes to the single judge.
But we can agree, Milord, to at the time of admission, Milord, matter can be
Always,
resolved
always.
by the division bench.
Yes, we do that. The rule does not provide that, but we do that at the admission stage. taking consent of the parties to expedite matters. That we can do.
In this case, I would request for
That's
that.
very well.
You know, this
My
is
lord, the order against which, my lord, we've come up against your lordship, my lord, certain points of law, since it's the second appeal, virtually speaking.
Yes.
My lord, the points of law would have to be admitted.
Because the RERA also provides that substantial question of law, probably.
My
Do you have a
lord,
copy of the
without
RERA?
taking without taking your lordship's leave, we have taken the liberty of just, I'm sure my learned friend will also have no.
You have formulated
But I am-
questions.
It's formulated.
On the other hand, even though I'm appearing for the respondent,
You're considering to this.
I want your lordships, my lord, to consider this appeal. There is only one prior instance before this of the Rajasthan High Court, and this is, my lord, a matter which requires consideration and decision.
But we have to be satisfied that we have to admit the appeal.
Yes. But another thing also,
Yes.
my lord, I should tell your lordship, the Rajasthan High Court judgment, which my learned friend talks about, does not really apply.
We suppose we have to
Yes.
postpone it for a day or two, because the difficulty will be it cannot remain as an SAT. It has to become an SMAT. Number has to be allotted. The difficulty arises when it's renumbered, then whatever orders we passed in the prior to that, you may not find it in the same. I mean,
We won't take the chance today, just give the direction.
just we'll give the direction and then we'll direct the office to do the renumbering. You will be just making the necessary correction in the memorandum, just writing SMAT.
For Monday, my lord, for admission.
Yes, and it will be memorandum of appeal from the judgment of appellate tribunal. That is all right. SAT will be SMAT.
Monday is a holiday. It's the holiday.
Monday is a holiday. Up to 16th is the next working day. 21st, very well, no difficulty.
We'll come, my lord, for a hearing on that day, subject to your lordship.
Yes, very well. Give an indication to Mr. Bose of your points, or then we.
He knows that his appeal is liable to be
But
dismissed.
then I am not really pressing the point of interim order now, because the appeal has not formally been admitted and the points of law have not also been.
No. Keep those with you.
He'll argue everything to.
Yes, everything on
21st.
The appeal has been classified.
I was
Yes, Mr. Datta,
I
you
was
are-
assisting.
Yes.
Yes, Lordship inquired about SMAT 4 and SMAT 5. Once
Yes.
it was admitted by Tandon's bench, it was heard by a learned single bench as a second appeal,
Right,
and the judgment is reserved. Just for an update.
Yes. So that is the
Because
exact
I was
purpose.
there in that matter, SMAT 4.
Yes, right. You were there.
An example of opportunism when my learned friend understood that today is not going to be a
No.
full
I
high
heard
court,
Lordship saying
he's
about
gone to
SMAT.
greener pastures.
You also do that sometimes.
The appeal has been classified as a regular second appeal, whereas it arises from an order passed under the West Bengal Real Estate within bracket Regulation and Development bracket closed Act. What is the year of the Act?
2016. No?
Year 2016. Thank you. 2016. What are rules? 2016. Footstep accordingly, leave is granted to the learned advocate on record for the appellant to carry out the necessary amendment to the memorandum of appeal by classifying the same as SMAT instead of SAT. Footstep, next para. The learned advocate on record for the appellant shall also incorporate the name of the it's not a judge, the chairperson. Thank you. The chairperson who passed the impugned order in the preamble of the memorandum. Footstep, both such corrections shall be carried out during the course of the day. Footstep, the office is directed to reclassify the appeal and allot an SMAT number.
SMAT RERA, man.
SMAT, no, there is no such classification in the either the because the computer classifications are there in our rules. There is no such classification. Justice Tandon carved out a classification and the office followed it in one or two matters, but there is no such classification. So we will be in a soup later on when we show disposals. The office shall carry out the necessary SMAT number by April 16, 2025, full stop. The matter shall next be listed under the same heading on April 21, 2025. ফাইলটা অফিসে পাঠিয়ে বলবেন অর্ডারটা দেখে নিয়ে সেই অনুযায়ী কাজ করুন। Please carry out the corrections just right now, whenever you can.
Great. Will it
Thank
be my lord's pleasure to carry out the correction before your lordship's office?
Yes, here only.
Grateful.
Thank you.
Grateful, ma'am.
On behalf of the respondent number 7, my lord.
You lost the caveat
It's
Mr. Chatterjee,
yesterday,
Mr.
the
was
matter
appeared
was,
yesterday, my lord, he's not here today.
for the other respondent. So
my lord, can it be possible to fix it on 21st? Because next week I have some diplomacy.
if he agrees,
Yes, my lord.
none appears for the he was for respondent numbers who? None appears for the respondent numbers 1 to 5 at the time of call. Full stop. Accordingly, let the matter stand adjourned till April 21, 2025. Give your names, both of you. Yes. মিথ্যা মামলা করবে ভীষণ ঠকিবে ছেড়ে দিন নট টুডে অর্ডার করুন
For the respondent, my lord.
Respondent. None appears for the appellant, although the respondent is represented through counsel. Let the matter stand adjourned for the day.
Grateful.
Not today. দেখি আগের অর্ডারটা কি ছিল যাই থাক আজকে তো রেজলিউশন ছেড়ে নট টুডে নট টুডে অর্ডার রেকর্ড করতে হবে সেম
Lordship, item 40 I appear for the appellants. May I have your Lordship's kind leave to appear virtually, my lords.
You are for the appellants also?
No.
Oh, I see. Yes, Mr. Mukherjee,
Yes.
you can.
My lords, this is an appeal against an refusal to pass an ex parte ad interim order. The suit is essentially a suit for delivery of and cancellation of a gift deed by which, by dint of which 5,000 shares were transferred from of a company.
Right.
By the plaintiff's father. There are two plaintiffs, my lords, their father. If I may just tell your lordship, this is the suit. May I tell your lordship, the plaintiff's father was involved in this defendant number 1 company. Defendant number 1 is the company. This was a company in which the plaintiff's father was there since the beginning. And there were 2 directors. Upon the death of one, defendant number 2 became another director, who was essentially the managing director of the company. Defendant number 1, the plaintiff's father, and defendant number 2, they were managing the company. Now, in December 2015, the father of the plaintiffs passed away. Upon the passing away of the father, it was understood by the parties, and they shared a very good family and a cordial relationship, that the shares would eventually be transferred. Nothing like that took place. A lot of requests were made because of the fiduciary and the relationship that they shared.
The shares held by the father of the plaintiffs in the company.
In the company was supposed to be transferred to the plaintiffs.
The plaintiff.
Yes. Now that did not happen.
Oral agreement, understanding.
No, lordship. As after the death of the father, the plaintiffs would have received the shares, being
No,
the
that
heirs
was an
of
oral
the-
understanding or your
No,
impression?
lordship, so after that, after the father passed away, it
Yes.
is the plaintiffs who sought for the who made the request that as per them being heirs, it needs to be transferred to them, the shares, which was not transferred. Now, lordship, thereafter in 2022, it is for the first time when the plaintiff number 1, being a lawyer and specializing in income tax, when he was checking the financial returns of the company, which is uploaded in the MCA website, he finds that first time in 2022 September, in the financial records before the MCA, it has been disclosed that the shares of his late father has been transferred to defendant number 3 by dint of and the date of execution of such transfer predates the death of the father, that is in 2015. So the first time in 2022 we learned about this. Thereafter he made representations, he made a police complaint saying that all this is a fraudulent case against all the defendants herein. Thereafter in 156(3) was was proceeded with. In that 156(3) applications, my lords, it has the court had directed the police officials to do a preliminary inquiry. In that inquiry, certain documents were submitted before the court, which finally in December 2024, when the documents were submitted, we obtained a certified copy. And we see that there is a purported gift deed which has been executed supposedly by the father of the plaintiffs way back in 2015 before his death, by which he has gifted 5,000 shares of face value 10 each without any consideration to a third party, saying it's out of gift, out of my love, though that person's no more there. Lordship, there are 2-3 documents which I have received as a part of the certified copy itself, which ex facie will show that the apprehension of the gift deed being fraudulent has got some substance in it. On the basis of this, we have approached the court for cancellation of the gift deed and subsequent declaration that we are the owners of the share and an injunction.
You have also implemented the transferees of the shares.
Yes, my lords. That is the defendant number 3.
Oh, they themselves. They are the. They are
Defendant
also
number 1
directors of the company. They transferred. It was transferred to them only.
Lordship, and subsequently he becomes a director of the company. Is what we now
became
Lordship,
directors. That's very
because as of now we do not know what is the state of the company and who are the directors and what's the internal.
So you have
things.
implemented them in the capacity of directors.
Lordship, I've implemented them as
Anyway,
directors.
why was the injunction refused ad interim?
Lordship will kindly see the impugned order. Lordship can see it from the memorandum. Lordship, the 4th paragraph, if I may just place it, Lordship, it is after going through the plaint and injunction application, it has been found that there are several confusion regarding the role played by plaintiff number 1 and plaintiff number 2, as reflected in paragraph numbers 5, 6, 7 of the plaint and as reflected in paragraph numbers 4, 5, 6, 7 of the injunction application. In the plaint, confusion is there with regard to the list of documents annexed to the plaint. As per the statement, only the gift deed dated so-and-so is annexed document of the plaint, whereas several other documents have been filed with the plaint and also with the injunction application, which have been referred at the time of hearing. Be it mentioned here that the cause of action of present suit arose first in November 22 and then on June 24 and finally on December 2024, as per paragraph number 21 of the injunction application. But it is not stated when the plaintiffs came to learn that in connivance and collusion with each other, defendant numbers 2 and 3 are attempting to transfer, alienate the Schedule A shares. If I may, Lordship, it is basically that if what I have understood, that there is some poor drafting is what might have been the case, what I understand. But my lords, I have personally checked up the plaint and the injunction petition. I can take my lords through the paragraphs which have been referred to herein, and I do not find any confusion therein, subject to what my lord finds. Secondly, my lords, it is always a procedure that in a non-commercial suit, only the deed which is sought to be impugned is annexed with the plaint, and other documents are annexed with the injunction application. So my act
No, if
of
you rely on documents now, present order 6 read with order 7 mandates that you have to file the documents, copies of the document. Whatever you rely on in the plaint.
In the plaint, and that has been filed in Firisti. That's what is recorded, my lords.
That has been done. That is a list of documents.
Lordship, that is the list of documents.
But you also have to file those documents, copies of those documents with the plaint.
Lordship, it is filed in the originals are filed with Firisti. The originals of the documents.
Those have been filed.
Those have been filed with Firisti in the court below.
All right.
May I just show your lordship the gift deed and 2-3 more documents which were
The
there
reason,
before.
apparently the reason is that confusion, apart from the confusion, you have not disclosed the date when you knew about the knowledge of illegal attempt. Illegal attempt means by virtue of the gift deed it has been transferred. So you have stated
Lordship.
about when you derived knowledge of that gift deed. That you have stated.
That I have stated, my lords. That I have derived knowledge. The certified copies are there in my lord's brief. I have obtained the certified copy in December 2024, and this suit was moved in January 2025.
Very well. What is the sort of injunction you are seeking?
That during the pendency, they do not further create any other charge on the shares. Otherwise, lordship, the beneficiary of the transfer is made a party. If he subsequently sells off the shares or transfers the shares, then it would lead, lead to multiplicity.
Yes, please
That
rely
is
on
the
whatever.
only precedent that we-
You're going to rely on certain paragraphs or documents, whatever you do that.
My lords will then just kindly see the documents once. My lords, just kindly sees the gift deed. It is in page 177 of the stay application.
Yes.
Lordship, is a part of the certified copy that has come, so the pages are not one after the other. That's how we've received the certified copy. Lordship kindly sees the marks the date of the gift deed, 10th April 2015. It is between Tapon Kumar Chakraborty, the father of the plaintiffs, and Ashit Kumar Ghosh. Lordship kindly comes to page 175. This should have been the second page thereafter, but because of the certified copy, it's come in the first. Lordship, this is how it's come, so I could not make changes in the certified copy that we received. Kindly just comes to, this is the, Lordship kindly sees the second paragraph in page 175. Whereas the donor voluntarily has made a sincere and conscious decision to gift his shares to the donee, recognizing his capabilities to fulfill the responsibilities. Donor is desirous of gifting the shares to a donee without any consideration or conditions thereto. My first
it was given only to Ashit Kumar Ghosh. Why was Maya Rani implicated?
Maya Rani, Lordship, what I have pleaded is that the entire fraud has been done at the behest of Maya Rani, she being the managing director of the company.
Very well.
Lordship,
Yes,
this
please
is the
continue.
gift deed. This is a gift deed, Lordship. There is no relation between the donor and the donee. And the first apprehension is that without any consideration, shares worth face value 5 lakh has been given.
No relation means Maya Rani was a co-director along with your father.
Lordship, the donor and the donee have no uterine or blood relationship.
That is not a necessary consideration.
That is the first apprehension. That's the first apprehension, my lords.
No, Maya Rani and Ashit Kumar, what is the relationship between them?
None that we are aware of, my lords.
Ashit Kumar and Maya Rani interstate also no relation that you are aware of?
No.
Apart from the surname, there is no other relation according to you?
Nothing that we are aware of.
Very well, very well.
Lordship kindly takes up.
So then why did Maya Rani call you to have it transferred to Ashit?
Because my lords, maybe it is her yes man. I have not been able to find out any direct relationship to bring before this court. Lordship, upon the death of Tapon Kumar Chakraborty was on 31st December 2015. Now the death certificate has been annexed. What I wanted to show, my lords, is that upon the death, Lordship kindly sees page 170. This is also a document which the police has found out, and we have received a copy of it from the certified copy. This is a resolution passed, has my lords got it, page 175.
170, yes.
175, my lords. This is a resolution dated 18th day of January 2016.
175 is the second page of the gift deed. What are you saying?
170, my lords. 170. 170.
Yes, 170 you said for at the first.
No,
Yes,
sorry, I apologize.
170, yes.
Lordship, this is also been retrieved by us from the certified copy of the police, my lords. My lords will kindly see this is a resolution of 18th January 2016. Lordship kindly just notes the wordings. Resolved that the board of directors of the company express their deep condolences at the untimely and sad demise of Mr. Tapon Kumar Chakraborty, who died director of the company on 31st December 2015. The directors place on record a deep appreciation for the valuable services rendered by Shri Tapon Kumar Chakraborty, who died during his tenure as a director of the company. My lords, if by way of the gift deed in April 2015, if that was there, he would have given up all his shares.
That was vis-a-vis the shares. That was vis-a-vis shares.
Lordship.
Directorship is on a different footing. Shareholder and different capacities.
Lordship, but there is no document in our that we are aware of wherein he was thereafter appointed as a director even after giving up all the shares. Because, my lords, I will show one more document where in September 2015 he has signed all the returns of the company as a director. Lordship, he was holding the position of a director based on the shares. If he gives up the shares, then he would not be a part of the company, my lords.
Is there any bar in law? Although it is counter-logical that a director should not have any shares, but two questions. One is whether 5,000 were the total number of shares held by Tapon, or he had other shares also. It was the total number.
shares.
Total.
Total number of shares, my lord.
Total
Yes.
number. Is there any legal bar in the company law for a director to operate without having any share at all?
To the best of my knowledge, lordship, if there
It
has
sounds
to
very intuitive, but is there a bar
lordship,
in
then,
law?
lordship, then he would have to be appointed as an independent director or a special
Right.
director under a terminology, my lords.
Yes.
Then it should not be a normal director.
Maybe, yes. Very well. What
Lordship,
else?
also, lordship kindly takes up page number 133. Lordship, why was this document by which supposedly my father has given up the shares not even disclosed or even made a part of the returns? Lordship kindly takes up page 133. This is the form number MGT 7A.
Yes.
Lordship would have got it. Lordship, it is dated 30th September 2022. Lordship will find the date on page number 144. That is the internal page 12 of 13. Lordship will see this is a continuation. This is dated 30th September. And a part of this, my lords, Lordship will come to page 137. As a part of this continuation of the returns, page 137, Lordship sees date of registration of transfer, 12th April 2015. Date of previous AGM, 30th September 2021. Lordship, so a date of transfer in 15 between Topon Kumar Chakraborty and Ashit Kumar Ghosh, Lordship sees the transferer's name and transferee's name, was first time was disclosed only in 2022. A time when I was about to lose patience, and then I was following up very vigorously since his death. And with the receding of COVID, I was following up vigorously, and that is when this was made public.
And that also the details of shares transfers
Not
had to be since closure date of last financial year.
Lordship. So
And
in
this was
2000,
beyond that. Much
Lordship,
before.
Lordship, what I can infer from the document is in 2021, supposedly in the AGM, this was made over. Because this is all we have got. This is from the public records that we can download from the MCA, my lords. And Lordship, the resolution that I have shown previously we have received it as a part of the certified copy of the lower court orders. And this is what we received from the MCA portal, my lords. This is the document which prompted us to go and seek our rights from the defendant number 2, who was the managing director of defendant number 1.
All right.
My lords, I would just take my lords to paragraph numbers 4, 5, 6, and 7 of the plaint, which has been impugned in the impugned order. Lordship kindly takes up page 27.
Yes.
So the impugned order talks about paragraphs 5, 6, and 7 of the plaint. Lordship kindly peruses paragraph 5. If I may, I can place it, my lords.
Yes.
Paragraph 5. The plaintiff himself is a lawyer specializing in taxation laws, and as such was busy in his career. Occasionally, he contacted the defendant number 2, the managing director of defendant number 1 company, to ask for updates on the transfer of shares, and the defendant number 2 time and again assured him of the same being under process. It is pertinent to mention that considering the long-standing family relationship between the parties, the delay did not give rise to any sort of apprehension in the mind of the plaintiff. It is further pertinent to mention that the plaintiff kept checking the master data and other publicly available records of the defendant number 1 company time and again, which never showed any change and or alteration in shareholding of the defendant number 1 company, tantamounting to the plaintiff not questioning the bona fide of the defendant number 2. Acting in pursuance of and under the same bona fide belief, the plaintiff disclosed such shares of the defendant number 1 company to be a part of said Shri Topon Kumar Chakraborty since deceased estate after his death, when the tax returns for the assessment year 16-17 was filed by the plaintiff on behalf of his deceased father on 31st March 2017. Because Lordship, we believed that it remained to be my father's property. Sometimes in November 22, when the plaintiff was checking the financial returns of the defendant number 1, he was shocked to learn that the defendant number 2, acting in collusion with defendant number 3, had uploaded an entry as is evident from the form number MGTA 7A of the defendant number 1 company for the financial year ending 31st March 22 in the nature. Lordship, the form that I showed.
Yes.
So, Lordship, I do not find any confusion in this paragraph. With the deepest of respect, my lords. This is the story which I have placed before my lords, the stories which we have also run.
Right.
Lordship, this is in addition to the usual grounds of that the signature is not of the father, and there is other frauds which I have pleaded, my lords. Those are the usual pleadings I'm not taking, because I also find that I want it eventually in the trial to prove that the signature would not match my father's. All I'm here before my lords is that today, during the pendency of this trial, Lordship, at least there be no further transfer of the shares by the defendant number 3 to anyone else, considering he's the owner of it.
Right.
I'm not claiming any benefit till I can prove my case before the trial. This is my plaint case. If my lord just kindly sees the prayers of my plaint, Lordship also takes note of paragraph 15 in page 32 of the plaint. This is where I have laid down the particulars of the
grounds of
frauds that-
challenge.
Lordship, the particulars of all the frauds.
No, also that your father was still a director, shown as a director in the resolution from the resolution. That has
Lordship,
not been
that
given.
is a resolution which I have received from the police. That is there. That's not a document that was even in my custody, my lords. So
No,
the resolution.
did you refer to that in your plaint?
Yes, my lords. I have referred to that.
Where?
I'll just show my lords where I have referred to that. Just in a moment, my lords. My lords, just gives me a moment, my lord.
Yes.
My lord, it's there a part in my should be the same, my lord. Just Lordship, page 33, para
Yes,
D.
you've got
Lordship, I have mentioned
para-
about the resolution.
page 31 also.
Lordship, and
Page,
page 33.
page 31 actually.
My lords. The board meeting, my lords.
No, you have referred to that document, especially minutes of a board meeting dated, which is also wherein the defendants had acknowledged the service of as the director.
Which I received. Lordship.
Yes.
Now, in my prayers, because I've just sought for delivery up and cancellation of the gift deed, so only the gift deed was annexed with the plaint. The others have been relied upon in the plaint, which was filed in Firishti, which is there before the court below.
And you have also annexed the injunction application.
Lordship, it's also annexed with the injunction application.
Very good. Let us hear Mr. Mitra then. Let us formally, in a sentence, we'll admit the appeal and then hear it.
Was possibly done.
That was already done. We have admitted the appeal.
No, my lords, no formal order to that was made, my lords. It was just an order was made for us to serve a copy.
In view of several arguable questions having been raised, comma, we admit the appeal for being heard on the grounds taken in the memorandum of appeal. Full stop. Thakai birthday. Yes, Mr. Mitra. Why shouldn't you grant an injunction now? I mean, now you're hearing the injunction application, so we can hear you.
Now, my lord, to cut short the matter, I can satisfy your lordships on the merits. To cut short the matter, my lord, the MCA record would show that, my lord, the defendant number 3 had already transferred the shares, my lord, in 2024, long before filing of the suit.
The defendant number 3 transferred in favor of some other third party.
Yes.
the daughter of the defendant number 2. The question fell from your lordships whether, my lord, the
Relation.
defendants number 2 and 3 are related, my lord. As far as I know, my lord, I did not check the records. As far as I know, my lord, they are, my lord, brothers and sisters. Brother and sister.
So this injunction would be, I mean, toothless practically.
In any event, my lord, the law is well settled that whether, my lord, the order is wrong. Your lordships, my lord, my learned friend had relied on the first part of the impugned order. The second part of the impugned order was knowledge from 2022. I'll go, my lord, far back. If your lordships kindly look into the plaint of the, my lord, trial court petition, either of it. My lord, admittedly, my lord, Papan Kumar Chakraborty died on 31st December 2015.
Yes.
Now, if your lordships are, my lord, please to come to the plaint, my lord, since my lord, and the before that, my lord. To my knowledge, my lord, the Companies Act does not prohibit, my lord, a non-shareholder to become a, my lord, director of the company. Nothing, my lord, special permission or nothing is required, as was, my lord, suggested.
Is he
If the
required to be
memor-
shown as independent director or something?
it's not.
There's no such requirement.
If, my lord, the memorandum and articles of association provide that, my lord, a director has to have, my lord, a qualifying share, then only, my lord, the question arises. I, my lord, asked, I did not personally check up. The memorandum of the company does not provide that. Now, kindly come to the plaint once, my lord, page 25, or the petition, my lord, page 40. This, my lord, the stay petition, my lord. It's really, my lord, copy of the plaint. The stay petition.
So since you are following the plaint, we can follow the
Yes,
plaint. Yes.
very. Kindly come to page 25.
25 years.
Kindly give me a minute.
Yes.
Because I was following the petition.
Oh, no, you
I'll follow the
difficulties.
plates. I'll just, my lord. Kindly come to, my lord, paragraph 3, page 27.
Yes.
Tapan Kumar Chakraborty, my lord, he died on 31st December 2015. It was a well-known fact that even at the time of his death, he remained to be the shareholder of the defendant number 1 company. Share scripts are not produced.
Hmm.
The share scripts ought to have been with Tapan Kumar Chakraborty and his heirs, the son and daughter. Those are not produced. Now kindly come to paragraph 5. The plaintiff himself is a lawyer. Kindly pause here for a moment. He being a lawyer, my lord, and my lord, the rest of the petition, it would show because he was regularly checking up MCA portal, that is his case. Did he apply to the company? He ought to have applied for, my lord, the transmission or transfer of the shares. Or they. They did not. That's, my lord, the normal course. Instead of checking up, my lord, MCA portal, an application. Maybe a formal letter that please transfer the shares. Not a single letter, even. Now they go on to say, paragraph 5, my lord, page 27, I was the second sentence. Occasionally, he contacted the defendant number 2, the managing director of the defendant number 1 company, to ask for updates on the transfer of shares. Now, without the application, it cannot be done. And the defendant number 2 time and again assured him of the same being under process. Still not a single letter. It is pertinent to mention that considering the long-standing family relationship between the parties, the delay did not give rise to any sort of apprehension. Well, that's 7 years. Nothing done. Then, my lord, kindly come to paragraph 7.
2022 knowledge.
Yes. Sometimes in November 2022, when the plaintiff was checking the financial return of the defendant number 1, he was shocked to learn that the defendant number 2 acting in collusion, etc. Still, the suit is not filed. Or, my lord, the company law board is not approached. I proceed on the basis, I mean, by NCT, not the company law.
Yes. No.
Now, I proceed on the basis that he was not aware of the gift deed, but he was aware of the transfer. He ought to have applied for rectification. That was not done. He is a lawyer, tax practitioner. Then, my lord, he relies on the tax return that is, my lord, that would appear, my lord, paragraph 7.
Mr. Mitra, shares are heritable otherwise.
Absolutely.
No, is an application for transfer mandatory? Under the company law, it is mandatory. Without an application, there cannot be a transfer.
So, my lord, there has to be an application.
Yes, because Companies Act provides for application for transfer, definitely.
It has to be recorded. Now, my lord, the company has to know, my lord, who is the heir.
Right, right. Yes.
Now, I was on the conduct, my lord. After, my lord, 2022, the no approach is made.
Which is also reflected from the order. That is also one of the,
Yes,
as you
that
said.
is the ground. First part, my lord, the document production, my lord, I also really could not follow, my lord, what was the latches or what was the lacuna. But second part is the main part. If somebody slips from, my lord, 2022, my lord, and suddenly, my lord, comes and says that, well, I came to know about the gift deed in 2024. In that view of the matter,
But it's couched in a peculiar language. The court says, cause of action for the suit.
Somebody like me has written it with the knowledge
We
of
only
the
honestly hope that somebody like you had written it. We did not hope, actually. We wouldn't have any business then if everybody wrote like you. But even then, Mr. Mitra,
yes,
you follow what we are saying, because it says that suit arose, cause of action, yes. Up to that, it's all right.
Yes.
That's not given as a reason. Arose first in November 22, then on June 2024, and finally on such and such. But it is not stated when the plaintiffs came to learn that in connivance and collusion with each other, you are attempting to transfer and alienate.
That is
This
the
does not
petition
mean
part.
anything.
That is the petition part. The allegation is that in connivance they are trying to transfer.
Where is the question of trying to transfer? It has been transferred. That is the cause of action of the suit.
No.
Oh, for the transfer.
Further
Acha, very.
Further
Yes, yes, yes. Right.
And, my lord, as I said, my lord, I can produce the document, my lord, the return of, my lord, 2024.
But Mr. Mitra, definitely I've got a point in whatever you said. But at the end of the day, the suit has been filed for challenging that gift deed. Now, they are entitled to produce whatever evidence they have, to seek for a signature verification maybe, or whatever. Not for the asking, but at the ad interim stage, court had to proceed on the pleadings of the...
You know, 2022 and, my lord,
2022 is the main ground.
2025.
So urgency factor is...
2025.
Urgency factor is...
My lord, if somebody, with respect, my lord, if somebody wanted to defraud, my lord, in 3 years, my lord, possibly 300 times transfer could have been made.
What is their explanation for filing it in 2025?
Kindly see para 21, my lords.
21.
That's
Yes,
Page 1.
21. Cause of action
Or
for...
Page 2. Para 21, my lords, of the
First date is relevant. After that, whatever happens, came to learn of
the certified copy of the first time we saw it was in 2024 when we
All right,
obtained
all right.
the part of the certified copy, my lords.
All right.
We went to the police, the 156.
Yes, yes, Mr. Mukherjee, you understood. Yes.
As I
Let
said,
him complete, we'll come back to you. Yes.
Absolutely, man. Just to assist.
NCLT could have been approached immediately for rectification of the share register or the records of the company.
Yes, but the cause of action for the present suit did not arise. They are challenging the gift deed specifically.
That was the first one. The conduct, what I am trying to demonstrate before your lordship is the conduct.
That initiated the query in their mind that why did it happen, and they have given a chronology after that, that the criminal case was initiated and everything was. If the relief sought in the suit, Mr. Mitra, is not the rectification of the records. That could have been done before the NCLT, you're right. But the relief sought here
That ought to have been done.
ought to have been done, but they have proceeded before the criminal forum and every other forum probably.
Till they could have done that, my lord. Till they could have.
They could have, but that could not be a deterrent in the court not passing because yes,
that was, my lord, the civil relief.
Right.
Criminal case, my lord, still would not have given, assuming the gift deed was not there.
They could have sought for rectification, definitely, but they did not, suppose.
My lord, I would say they ought. It's my interpretation.
Yes, but if they don't do it, there is no bar because they registered.
No, there is no bar. I do not say there is any bar.
Should it be registered gift deed? It's written in the plain prayer as unregistered gift deed.
No, it's share transfer deed. Share transfer.
No, that must be an error. Unregistered, it cannot be. Page 36 is their first prayer is the unregistered gift deed. That must be an error, Mr. Mukherjee. Unregistered.
No, my lord, the gift deed of an movable property does not necessarily require registration, my lord. So
This was an unregistered gift deed.
It's an unregistered gift deed, my lord.
Very well.
And as I have said, my lord, that
you have transferred third party. Mr. Mukherjee, what about that? Even if you
I can produce the document, my lord. I have.
Yes, unless you get an opportunity, you cannot. Yes,
Mr. Mukherjee, in 2024, when we received the police report, that
we appreciate what you are saying. We appreciate what you are saying. But as of today, Mr. Mitra submits on instruction and he has got a document that the defendant number 3 has transferred the share.
In that event, my lords can at least give.
Therefore, this injunction cannot be granted.
My lords, because the company is before my lords.
The company, you say the company can
before my lords. Some sort of protection that any further transfer, not without a leave of the court, or some sort of that this would be bound by this suit, because lordship, otherwise I lose. I don't even know who's the next new transferee. And lordship, one more thing that my learned senior friend was saying about the NCLT, my lords. My lords, there is a division bench of our Honorable High Court presided over by Justice Sen, where Justice Sen has recorded, and lordship, I was carrying a judgment because of my absence from the court. I am not carrying it. My junior might not have it. It says, my lords, that NCLT can only be approached if the rectification is self-evident and it does not call for any serious inquiry or adjudication of fraud. May I just hand over a copy of this judgment to my lords during the course of the day? Lordship, here what happened is a suit was filed somewhat on the similar reliefs that I am claiming in my suit. Justice Rao, sitting in the single bench, said the suit would be maintainable, does not require to go to NCLT because the question of fraud is there, and fraud is something which a summary court in NCLT cannot determine.
True.
An appeal was preferred, my lords. Justice Sen and the division bench of our honorable court has held that yes, that is the correct.
Can you give the citation, Mr. Mukherjee? Do you have the citation or it's an unreported?
2023 SCC online Calcutta 1812. I will hand over a copy of this during the course of the day, my lords. It's Phulchand Gupta versus Mukesh Jaiswal. If
Mr. Mitra will grant an interim injunction.
Lordship, only one thing.
2023 SCC online Calcutta 1812.
Just
1812. Yes.
Lordship, Justice Kumar was a part of this judgment, my lords. It was.
If he is made to remember every judgment he has passed, then it will be very
I just because I'm not having a copy, just for.
So therefore, you are citing Justice Kumar.
No, just for Justice Kumar's reference, my lords, I'll hand over a copy to my lords' officers in the next half an hour, my lords. I'll just get it.
Can I do one thing, my lord? Can I come back tomorrow? I will tell you, Lordship, because, my lord, I once, my lord, said that they told me that they have no intention. It's a family business. It's now the mother and daughter, they are there. Now, I would like to, my lord, they are not here. And
No, but the company, you are representing the company also.
yes, all.
Oh, right.
I will take instruction that there would possibly be no further transfer. Your lordship can
Dispose of
record that,
and dispose
but
of and
kindly
directly.
do that tomorrow, my lord.
Very
They are
well.
not here, my lord.
And you bring the copy of the judgment tomorrow also.
I will. I shall, my lords. I shall.
During hearing of the injunction application, learned senior counsel appearing for the respondents seeks a day apostrophe adjournment to seek further instructions on certain issues. Full stop. Accordingly, let the matter stand. Let the injunction application stand adjourned for the day. We are not disclosing the issues in our order. If it fails, then it will be very embarrassing for. Yes.
So, Lordship, this will appear perhaps
Tomorrow.
Tomorrow's hearing days. If your Lordship needs some extra preference on this tomorrow, because of this instruction, Lordship can keep it.
Very well. Very well. Listed tomorrow. যা বললাম before the hearing matters. এটা না প্রথমে দিয়ে দেবেন টু বি মেনশন পেনশনের পর পাঠার এবং হিয়ারিং এর আগে এটা দিয়ে দেবেন এটা নিয়ে তারপর পাঠারে ঢুকবো কাল তো হিয়ারিং ডে না কাল তো নর্মাল কোর্সে আগে হিয়ারিং ম্যাটার থাকে অর্ডার ফর তো তলায় থাকে এটা পাঠারের উপরে থাকবে কাল কোনো টু বি মেনশন আছে টু বি মেনশন গুলোর পরেই এটা থাকবে হেডিং
Can be for orders or anything, my lord.
For orders করে দিলে
I'm so grateful, my lords.
We have serious problems with headings and all. These are very crucial issues.
I just pointed it out at the last moment, my lords, about it being too. I'm grateful, man.
Thank you. 41, who is appearing? Nobody is appearing. Not today. Good. Is anybody appearing for the other side? Is there any caveat?
No, my lord, no caveat.
Then you
It's
can take.
against an injunction, refusal of an identity injunction.
There is no caveat.
No,
then you can take up today.
Grateful
Despite Mr. Chakraborty's earnest effort to implement the resolution of the bar. Yes, he's glaring at us.
It's very urgent also.
Yes,
Against
please.
a refusal of an injunction order, my lord. The fact is this, that initially, my lord, I just in short, I'm telling the facts. An application for revocation of a grant of probate was filed in this Honorable High Court, which was refused by the rejected by the single judge, Honorable Single Judge. Thereafter, an appeal was preferred, whereby
your client had filed that
revocation on the ground that actually, my lord, my client is a biological son of the deceased testator.
Yes.
Which fully knowing well, they got
transferred to somebody else.
They're not non-contentious. They filed they prayed for
without citing you. They have
yes. That's why, and hence, my lord, I'll just draw
the beneficiary. Who is the beneficiary?
Beneficiary was yes. Actually, the testator had two wills. In one will relates to the overseas property, where my client was a beneficiary, declaring him as his son and children. He had two daughters and one son.
Right.
My client, and in here, I in that application also the genuineness of the will was also questioned because it was an unregistered will.
This will, by virtue of this will, it has been given to the daughters.
Yes.
Indian property.
Yes. And somebody else also there.
All right.
And my lord, on the honorable division.
So you are not cited. That was your ground in the probate.
Yes.
Why was it sorry, in the revocation?
In the revocation application, as that suppression of facts that I am the biological son, but still I was not made a party or
non-citation.
Yes. Non-citation, and the genuineness of the will was also under question.
Challenge the signature also.
Yes. Signature, and it was unregistered will because they
unregistered. It may be.
That may be because where the word term stepson was written on indicating my client. That's why the genuineness was
stepson was
That's why the genuineness was challenged, and thereafter, my lord, I have filed a appeal against that order before the honorable division bench. And my lord, kindly come to the order of the honorable division bench. It is page number 32 of the application, my lord, the present application. Only the operating portion I am telling, reading, my lord. Paragraph 7. of that the order judgment.
Yes.
Order dated to 11th of February. The since an action is contemplated by the appellant for establishing his right, there shall be an order of status quo with regard to further administration of the estates for a period of 4 weeks.
So by virtue of this, you file this title suit, declaration of your title.
Yes, yes. And there I prayed for a DNA test with to prove the paternal lineage, my lord. And there I prayed for an injunction not to admit
Deal with the property.
Yes, not to deal with the property, but that was refused, my lord. The order of that initially I filed a put up application. Then the learned trial judge said that in the appeal, my lord, the order is annexed. Learned trial judge
Where is your injunction prayer in the trial court? We'll just look into that. You have not annexed your plaint.
Have not I prayed, believe, my lord, the injunction prayer.
Plaint injunction should have been annexed. Ms. Either you are sufficiently senior for that. Plaint injunction is the main thing because the injunction order is based on that.
My lord. My lord, the prayer is in page number 7, my lord, and the injunction prayer.
But the probate has been granted. The revocation has still did been not been revoked. Revocation has been dismissed. As of today, there is a valid will in the eye of law.
Yes,
Can
my
the
lord.
civil court grant an injunction restraining operation of that probate? Injunction from dealing with the property we could have understood. But there is an existing probate. Probate is a judgment in rem. And your declaratory suit will culminate in a judgment in personam. Can such a civil court grant a stay? In effect, it's a stay of the probate. We don't think so.
Status quo was granted by the Honorable High Court, my lord.
Yes, but the manner in which it has been couched, you have asked for restraining them from acting on the grant of probate. Now, which is virtually a stay of the probate, and that is not in consonance with your plaint permanent injunction also. Your plaint permanent injunction does not say anything about that. It only says permanent injunction restraining defendants from denying the parents of the plaintiff. This is the only injunction you have sought. Page 7 of your plaint.
In the plaint, that is because I prayed for the DNA and to establish.
Then it is that will be an interlocutory relief. You have sought for a declaration that the plaint is entirely different. Plaint has no nexus with this property, in fact. See the reliefs in the plaint.
My lord, I understand, my lord.
Declaration that he is your father, Mr. Satyabrat Ghosh was your father.
And that was the direction of the Honorable High Court to establish my right before the to file the.
You could have preferred a suit for declaration of a title regarding the property. That is the meaning of the trial court, the High Court's order.
To establish the right, that is the.
You only seek a declaration that you are the son of your father.
My lord, I.
And injunction also restraining them from denying the parenthood. Nothing else. You have not. There is no schedule, in fact,
No, my lord, that is not there, but to establish my right. Actually, without the right, I was not allowed.
No,
to
this injunction then is beyond the prayer in the main reliefs made in the plaint.
But in the injunction application, I.
What is the ground on which it has been refused?
On the ground that since initially when I filed, my lord, it was they said that since the status quo is there, so come after the expiry of the status quo. Thereafter, I again filed. Then only on that ground, since the produce the application file and order when court filed.
This is a bad ground that this court has no jurisdiction to pass any order of injunction. No, this is correct. Let us see the order.
Only in the appeal, it has been annexed, my lord.
Yes. Honorable Justice such and such, Justice Somen Sen, this court finds that when the High Court has granted probate, this court has no jurisdiction to grant any order of injunction in respect of. Right. Not because it is a High Court, but since a court has granted probate, we do not find any scope of interference. We are giving you 2-3 reasons for this. One, that this is in deviance from the plaint reliefs, not in aid of the plaint. Secondly, probate is a judgment in rem.
My lord.
So, judgment at civil court while deciding whether you are the son of your father, cannot touch a probate proceeding. Cannot touch a probate proceeding unless it's a competent court, appeal against the probate or revocation or whatever, which you have rightly preferred, that is also pending. So the frame of the suit, in the frame of this suit, no injunction could be granted.
But the reasons, my lord, which have been cited, that is also not.
No, one of the reasons is good. Court does not say that because there is a prevailing order of injunction, I am not granting injunction.
No, that did not.
If that was said, we thought so.
No,
It
that
says
did
that the
not
High Court has granted the probate. Let us forget the High Court part. Court has granted probate. Therefore, this court has no jurisdiction to pass an order of injunction. Quite right. We will directly.
An ad interim order should have been passed, because unless and until my
No, the injunction application is not. The prayer is the injunction application is not maintainable in the face of the reliefs you have sought in the suit itself. If you filed a suit for declaration of title, then this injunction could have been granted. No corporeal rights to the property has been claimed even in the suit. In the suit, you have said you are the son of your father.
Yes.
You do not describe what property he has, paternity.
Yes.
You seek that declaration, but you do not say what are the properties belonging to your father, and as a consequence that you are entitled to that property. This is not a suit regarding the property at all.
No, that is not, my lord.
This is not a property suit.
That is that.
So how can an injunction be granted regarding a property which is not even the subject matter of the suit?
My lord, I bow down.
We are sorry, because এখানে তো suit-এর সঙ্গে কোনো nexus নেই। That is not even the subject matter. The property is not even there's no schedule to the suit. How can there be?
Property is not the subject matter of
No,
the suit
no.
also.
Then no injunction can be granted.
Since the right, this I just want to learn from
Yes,
your
yes,
lordship,
absolutely,
because,
please.
even my
No, it's an argument. You can argue with us.
no,
You
I
have a
just
right.
want to learn from your lordship, because it's my privilege to have a.
No, not at all. Please just continue. Without those, cut off those.
That's rights. I have to establish my right that I am the son of the deceased testator. So that liberty has.
Justice Shane provided the liberty. We should not advise you, because here, please come to page 32 of your application. Now here, court in paragraph 7 merely observes that since an action is contemplated by the appellant for establishing his right, there shall be an order of status quo with regard to the further administration of the estate for a period of 4 weeks. Paternity, you seek a declaration, fully agreeable. But then you also have to, because this will, the probate has been granted in respect of a particular property. Now, it's an well-settled position, as you know, that probate court cannot go into title. Now, if probate court cannot go into title, the only relief available to the person concerned is to file a regular title suit. In that title suit, probate will be one of the considerations. But a regular title suit is the remedy. Title suit is filed in respect of the property. In the suit, as you have framed, you could have incorporated a prayer for declaration of title regarding the property. That would be, in fact, a consequential relief. But in its present form, we cannot. You can seek a title. You can seek a declaration of your title.
Besides having a.
Besides all these will remain. In the same suit, you can go and file. We will give you that liberty also. We'll say that you haven't, in view of the present frame of the suit, no injunction could be granted. But nothing in our order, nothing in our order will prevent you from taking out an amendment application incorporating relief in the plaint regarding title to the property. We'll say that. The present appeal has been preferred against the refusal of an ad interim injunction filed by the appellant. Refusal of an ad interim injunction in connection with a suit filed by the appellant for declaration that one Satyabroto Ghosh is the father of the plaintiff stroke appellant, and for consequential reliefs, including permanent injunction restraining the defendants from denying the parents of the plaintiff. Next para, learned counsel for the appellant argues that despite the present plaintiff stroke appellant being the biological son of Satyabroto Ghosh, the alleged testator in a will, probate of the said will was granted without citation on the present appellant on the pretext that the appellant is not the biological son but a double inverted stepson of the said testator. even in the will, comma, which the appellant claims to be manufactured, comma, it was stated that the relationship between the testator Satyabroto and the plaintiff was that of a stepfather and stepson. Full stop. Next para. Learned counsel submits that an application for revocation was filed before a learned single judge of this court, which being dismissed, an appeal has been preferred, which is now pending. Full stop. In connection with the appeal, comma, an interlocutory application was moved, and in connection and in respect of the same, comma, the concerned division bench taking up the appeal, comma, by an order dated February 11, 2025, comma, inter alia observed that it made clear that the status of the appellant is not decided in the appeal, and such an action is contemplated, such an action, and since an action is contemplated by the appellant for establishing his right, comma, there shall be an order of status quo with regard to further administration of the estate for a period of 4 weeks. Full stop. Upon such observation, comma, along with the interlocutory application, comma, the division bench also disposed of the appeal itself. Full stop. It is submitted that pursuant to such observation, comma, the present suit has been filed for declaration of father-son relationship between the said Satyabroto Ghosh and the plaintiff. Full stop. Next para. It is contended that the learned trial judge, comma, while refusing the ad interim injunction, comma, merely cited the grant of probate by this court, comma, without taking into consideration the observation made by the division bench in connection with the appeal preferred against the same. Full stop. Next para. However, comma, we find that although there were some cosmetic errors in the impugned order of the learned trial judge, comma, we are agreeable with the conclusion of the same. Full stop. Next para. First, comma, the injunction, the temporary injunction sought, comma, regarding a restraint order on the defendants to act on the impugned grant of probate which was obtained from the High Court, from this court, is prima facie not maintainable, comma, in view of the fact that a judgment granting probate operates as a judgment in rem. Full stop. It is doubtful as to whether a regular civil court, comma, while deciding the paternity of a particular person, comma, could, comma, within the limited in personam scope of such adjudication, comma, injunct a party from giving effect to a probate, comma, which is a judgment in rem. Full stop. Next para. Secondly, comma, the injunction sought in the temporary injunction application tantamounts to the beneficiaries of the will, comma, in respect of which a probate has already been granted, comma, from dealing with the subject property of the will in any manner whatsoever. Full stop. However, comma, such injunction would be beyond the scope of the suit itself. Full stop. In the suit, comma, no property is the subject matter. Full stop. The suit revolves, comma, in its present form entirely around a declaration sought by the plaintiff that Satyabroto Ghosh is her father, and for permanent injunction restraining the defendants from denying the parenthood of Satyabroto vis-a-vis the plaintiff. Full stop. Next para. Thus, comma, in connection with such suit, comma, the court could not grant an injunction which would in effect restrain the defendants from dealing with the subject matter of the probate. Full stop. Next para. That apart, comma, we find that the prayers made in the injunction application itself are in direct contrast with and in deviance of the prayers made in the plaint itself, full stop. Next para. Thus, comma, the learned trial judge was justified in observing that in view of the probate granted by this court, comma, the said court had no jurisdiction to pass any order of injunction in respect of the said probate. Full stop. Next para. However, as such, comma, we do not find any merit in the appeal, and accordingly, FMAT 104 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Next para. Consequentially, Can 1 of 2025 is also dismissed. Full stop. Next para. It is, comma, however, comma, made clear that none of the above observations shall preclude the plaintiff stroke appellant from appropriately amending his plaint by incorporating reliefs in respect of declaration of title of the plaintiff to the subject property as well as consequential reliefs. Full stop. If such amendment is sought, comma, the learned trial judge shall independently decide the same on its own merits upon hearing the other side and come to a conclusion thereon. Full stop. In the event such amendment is allowed, comma, the plaintiff will be at liberty to amend the injunction application and or file a fresh injunction application seeking appropriate reliefs in respect of the property which is the subject matter of the will. No orders to cost.
Grateful to your lordship. Can a time be framed, my lord?
No, you have not yet filed.
No, I have not yet filed. If within
No, it
I
is
will
yet
file
to.
it within a week. If
No,
that
no.
can be done. I just
No, we cannot do that. We cannot.
Grateful.
It is not yet there. How can we direct the court?
Grateful.
I was Milord
Yes, Mr.
addressing your
Banerjee.
lordship's Milord on the appeal. It's my appeal from Milord grant of probate.
Right.
Milord, three sisters, Milord carbon copy of the will. Milord.
Yes. You also tried to impress upon us the daughter's marriage thing.
Yes, that one.
Yes.
Yes. Now, Milord, after my learned friend has Milord made over to me, Milord, a compilation of the documents exhibited.
Yes.
Milord, another startling fact, Milord, has come now.
What?
Milord, I'm really thankful to my learned friend, Milord, for that. Kindly, Milord, just have a look at, Milord, the bunch of documents my learned friend has handed over, Milord, which were the documents marked exhibits. And with these exhibits were, Milord, not available in the paper book, Milord, which was our fault.
So we are hearing the appeal itself?
Yes.
Yes.
Yes. Milord, I will take your lordship in detail to that. Just, Milord, just for a minute, quick look at this document. Milord, kindly turn to page 6.
Yes.
This was, Milord, if I go by, Milord, my learned friend's compilation, and which is correct, Milord, this was marked exhibit 3. Milord, the date of the document at page 6 is 21st August 1999.
Exhibit C.
3.
3.
1, 2, 3, Milord.
You are sure of that, both of you, so we can write that.
Yes. Milord, the judgment also says that.
No, if both of you say, we'll write. Yes. Exhibit C.
Milord, the date of the document is 21st August 1999.
Right.
Milord, the date of the will was, Milord, 15th May 1994. Milord, if that be so, and Milord, if this document is, Milord, taken judicial note of, then, Milord, this would be a codicil. Because this traverses beyond, Milord, the will, modifies the will, Milord, to some extent.
What would be the effect, Mr. Banerjee?
Yes, Milord, kindly take the will and, Milord, this document side by side.
Yes.
Milord, the will is at page 12. Milord, two properties were, Milord, the subject matters of the will. One was, Milord, a Kalna property, and the other one, Milord, was a Kolkata property. Debo Procedural property. Milord, the testatrix, Milord, our mother, Milord, she had 3 daughters. Milord, I just indicate the names. Milord, Taposhi, the eldest daughter.
No, page 12.
Yes, Milord. Of the paper book. Of the paper book. I'm
Oh,
sorry. I'm sorry. I'm so sorry.
Yes.
Milord, page 12 of the paper book and, Milord, page 6 of the bunch of documents. Kindly take these two documents, Milord, side by side.
Yes.
Now, before I take your lordships, Milord, these two documents and the contents of these two documents, Milord, just Milord, a brisk recapitulation. Taposhi is the eldest daughter, who is the appellant, who has been deprived. Milord, who was given Kalna property, and the most Milord valuable property was given Milord to her younger sisters, Shashwati and Vashwati. Shashwati is Milord the younger Milord sister, youngest sister is Vashwati. It was during Shashwati's marriage when Milord the property was bequeathed allegedly Milord under the will. Now, Shashwati and Bhashwati Milord got under the will Milord the Kolkata property. Shashwati Milord took the I'm sorry, Milord, Bhashwati took Milord the lion's share. Shashwati got Milord a part of it. Milord, the application for grant of probate Milord proceeded on a basis that Milord the will was executed. I will take your lordship to those averments. Milord, there was a carbon copy also Milord executed, Milord, simultaneously. And Milord, the carbon copy was placed along with the application for grant of probate. Milord, the court record says that Milord, later on, Shashwati, Milord, with whom the original was lying, she came, filed an application, and Milord just, Milord, may I say this word, dropped Milord in the court, Milord, the original will. She did not depose.
This is not barred. One of the attesting witnesses can.
Milord, this carbon copy does not tally with the original. Milord, the
does not tally with the original?
No. Milord, the tremors, Milord, in the signature.
Oh, that, right.
Those are not there. Milord, the pain control is different.
Sorry, to disable.
I'm sorry,
the original will was exhibited, marked as an exhibit.
Yes.
Suppose even if we disbelieve the carbon copy,
then with the entire story that Milord, this was executed. Then Milord, a suspicion, and Milord, that is to be dispelled.
All right.
Milord, the pain control is completely different in the carbon copy. Milord, this pain pressure, Milord, my lord, that would be so apparent. Milord, these tremors in writing, Milord, by an aged lady, Milord, those are missing in the carbon copy, which was Milord originally filed. And Milord, the angularities, Milord, of the Milord letters, those are also Milord quite different. Now, before I take your lordship to that, Milord, kindly Milord, take these two documents side by side. Kindly take Milord third paragraph at page 12 of the paper book. Milord, she says, Milord, if I take the will, Milord, on face value, I give, devise and bequeath my house property with furniture and fittings thereon in holding number 18 by 1. Milord, there is a overwriting and there is a initial, Milord, also there. In district Bardhaman to my eldest daughter, Taposhi Chaudhary, who is Milord, now the appellant before your lordships, wife of such and such, absolutely and forever. My second daughter, Shashwati, and third daughter, Bhashwati, shall get ground floor portion of the premises, the Devaprasad Row, Kolkata, in equal proportion.
This is a photocopy from the records.
Yes. Yes.
These scribblings are there in the original also.
Milord, these are there in the will, which is Milord inside the envelope. Milord, the original.
Yes. We saw on the last one.
But Milord, the LCR contains another will, Milord, which was Milord allegedly the carbon copy. Milord, I'll.
Yes. No, carbon copy and the original will was also exhibited.
True. True. But Milord, with an assertion that Milord, this was executed.
Yes, carbon copy. We understand that.
Yes. In equal proportion. And my lord will kindly, Milord, keep in mind that my lord is Milord reading a will, Milord, which is Milord drafted in English, signed by someone in English, but who was not acquainted with Milord English language as such. Milord, that came out of Milord from the evidence. And Milord was not Milord acquainted with legal language in any event.
It might have been drafted by somebody else for her.
Milord, there is a story also, Milord, Milord told to the learned court below. Milord, there were two attesting witnesses. I'm sorry, Milord, there is a break now. That is, first attesting witness was Milord the learned advocate who Milord drafted the will. At whose instruction Milord that did not claim because Milord he could not be examined. He had died. Milord, the second attesting witness, Milord, who is one of the distant relatives, Milord, he said that Milord he had gone Milord to the office of the first attesting witness, got it, brought it, and then Milord this was signed.
Achha. So then the first attesting witness did not sign in presence of the.
Milord, he says two things, Milord, in two different places. Show that also.
Very well. Let us proceed with
Yes,
this.
Miller. Get the ground. My second daughter, with the last paragraph at page 12. My second daughter, Shashwati, and third daughter, Bhashwati, shall get the ground floor portion of premises number such and such Deva Prasad Row in equal proportion. My second daughter, Shashwati, shall also get the first floor portion of the premises Deva Prasad Row with all furniture and fixtures thereon absolutely and forever. My third daughter, Bhashwati, shall get the open land in front of the house absolutely and forever. My third daughter Bhashwati shall also get the second floor portion of the premises at such and such address with all furniture fixture thereon absolutely and forever. Bhashwati shall get the roof, the terrace, the first floor and the second floor of the premises absolutely and forever. Bhashwati shall get the roof, the terrace of the first floor and second floor of the premises absolutely and forever. My second and third daughters, Sashwati and Bhashwati, shall equally and jointly get the staircase, water pump room with machinery, fittings, water reservoir in the premises, absolutely and forever. This is the bequest bit. Now, my lord, kindly take me the document at page 6, my lord, exhibit 3. My lord, they describe this as, my lord, a letter.
By who to whom? By the testatrix?
My lord, kindly, yes, by the testatrix to my lord Shashwati and Bhashwati. Kindly turn to my lord page 8 once. My lord will get two my lord nicknames. Mishtu and Mui. Mishtu is Shashwati, Mui is Bhashwati.
This was written in an envelope in which the letter was there.
Appears to be so, my lord. The evidence is also like that.
Anyway, yes.
My lord, kindly take the previous page. My lord, mother signs. My lord, there are also other letters which are exhibited. Kindly, my lord, turn to page 7.
This is more in the nature of a codicil, as you said. It's not a letter.
It's more in the nature
It's
of
not
a
tui
codicil.
pabi or tumi pabe. It's amar mejo me Shashwati pabe. So appears to be anyway.
Yes.
So
my lord, before I take your
signature is there on immersion.
Yes. My lord, she signs. My lord, after writing ma. My lord, if this is a letter, my lord, there are other letters also. My lord, where my lord she signed only as ma. Did not my lord sign in English. My lord, what was the necessity of signing, my lord, a letter in English while my lord, a mother is writing a letter to two daughters? My lord, there are other letters also exhibited. Nowhere in any other letter she signed, my lord, in English as on immersion. This particular document was required, my lord, to be signed as on immersion after saying that, my lord, she is their mother. Now, my lord, kindly take the contents of this document. Amar mejo me Shashwati Rai pabe. My lord, the moment she says this, my lord, this partakes the character of a codicil. আমার মেজো মেয়ে শাশ্বতী রায় পাবে কলিকাতার বাড়ির দোতলা ও যাবতীয় ফার্নিচার। একতলা শাশ্বতী রায় ও আমার ছোট মেয়ে ভাস্বতী রায় পাবে সমান সমান। Passage.
It is in consonance with the will up to this.
There is slight difference.
Dotola up to what you have read, it's same. Mejo me Shashwati pabe.
Milord, the lawn, milord, on the ground floor had gone to somebody else. But that was exclusively bequeathed upon milord the youngest daughter.
Yes.
Here milord it says shoman shoman. Then it milord clarifies saying that বাগানের অংশ ও টিন শেড পাবে আমার ছোট মেয়ে ভাস্বতী রায় একতলায়।
So specified which portion? Yes.
Milord, this expression tin shed was milord missing there in the will. It's there milord in this document. Then
বাগানের অংশ and tin shed.
Tin shed, milord, this expression was missing in the will. It's there milord in this document. আমার ছোট মেয়ে ভাস্বতী, there is insertion. ভাস্বতী রায় পাবে কলিকাতার বাড়ির, and my lord will kindly also milord have a look at the handwriting, milord, the tremors, the scribbles. কলিকাতার বাড়ির তিনতলা ও যাবতীয় ফার্নিচার। কিন্তু তিনতলা থেকে আমার মেজো মেয়ে শাশ্বতী রায় পাবে নিচু চৌকি ও তার বিছানা ওয়াশিং মেশিন।
Tintala was given
second floor, milord, will kindly turn to page 12 of milord the paper book.
Bhashwati was to get that.
Yes, Bhashwati, second floor portion of the premises.
Her daughter will get second floor
Yes.
with all furniture and fixture.
Yes, but here Milord Shashwati is getting something, Milord, from the second floor. কিন্তু তিনতলা থেকে আমার মেজো মেয়ে শাশ্বতী পাবে চৌকি ও বিছানা ওয়াশিং মেশিন। So Milord, there is a departure.
Yes, departure definitely,
There is
but a minor departure. Nichu chowki and all.
Milord,
One of the furniture.
Be it minor or major, Milord, once Milord, this will is modified.
Yes.
And this is an unregistered will, Milord. If my learned friend will correct me if I am wrong in saying so. Milord, if this is an unregistered document which is Milord shown as testamentary disposition, followed by another unregistered document which also Milord takes the character of a testamentary disposition referring to the previous document.
Does it?
Yes, it does so, Milord, in the later part of it.
যেভাবে will করা আছে, yes. Then
Milord, so Milord, there is a departure referring to the previous
the
document.
effect will be according
What is it? Milord, there cannot be, Milord, subject to, of course, correction by your lordship, no other second inference. No other possible, Milord, second inference.
So this should prevail.
Taken together, and once Milord, this is placed for probate, Milord, suppressing this, then Milord, the entire proceeding collapses. নিচু চৌকি ও তার বিছানা, ওয়াশিং মেশিন, সেলাই মেশিন, এলপি গ্যাস, সিলিন্ডার দুইটি, একটি রেগুলেটর ও তার পাইপ, বেলটেক টিভি পাবে। So Milord, almost all the furnitures on the second floor now go Milord to Shashwati.
No, these are not furniture. Washing machine, shelai machine, LP
Kindly
gas
see Milord what
cylinder.
was written at page 13.
Only nichu chowki, utar bichana.
Kindly take Milord page 13 of the paper book. Milord, what was originally written, if that was at all written. My third daughter Bhashwati shall also get the second floor portion with all furniture and fixtures thereon absolutely.
These are not
tolerable.
furniture or fixture. Apart from the nichu chowki,
Milord, I am not on the
bichana washing machine,
Milord, I am not on the
shelai machine,
grammatical
LP.
meaning of it. Milord,
No, no question of grammar.
Yes.
Even in any sense,
Very.
furniture is furniture.
So
Nichu
Milord,
chowki is furniture, but
ও তার
bichana,
বিছানা।
very well. Washing machine, shelai machine, LP gas cylinder, দুইটি regulator or what?
দুইটি সিলিন্ডার দুইটি ও একটি রেগুলেটর।
একটি regulator, Beltec TV, none of these are furniture.
Very well. Milord, these were not Milord there in the will. These articles were not, Milord, I called them articles. Milord, these were not there in the will. The will stand modified.
All right.
বেলটেক টিভি পাবে, বাড়ি ভাড়া থেকে দেবে আমার কাজের খরচ ও মিউটেশন ফি।
Yes.
যতক্ষণ না মিউটেশন হচ্ছে, কালনা ট্যাক্স ইলেকট্রিক বিল, নাও Milord, she is dealing with the property bequeathed upon me under this Milord property will. যতক্ষণ না মিউটেশন হচ্ছে, should have been কালনার ট্যাক্স ইলেকট্রিক বিল, কলকাতা ট্যাক্স ইলেকট্রিক বিল দেওয়া হবে, বাড়ি ভাড়া থেকে দেওয়া হবে।
So কলকাতার বাড়ি ভাড়া থেকে কালনা will be paid.
Milord,
just because he says yes, you don't have to say no.
No. Milord, it says from বাড়ি ভাড়া থেকে দেওয়া হবে, which was not Milord again.
যতক্ষণ না মিউটেশন হচ্ছে, কালনার ট্যাক্স ইলেকট্রিক such and such, কালনার ইলেকট্রিসিটি বিল দেওয়া হবে।
বাড়ি ভাড়া থেকে দেওয়া হবে doesn't say Milord which বাড়ি ভাড়া।
বাড়ি ভাড়া is referred to in the previous sentence also. বাড়ি ভাড়া থেকে দেবে আমার কাজের খরচ ও মিউটেশন ফি।
Yes, Milord.
Yes, it's a continuation of the previous.
Correct, but which বাড়ি ভাড়া Milord, that is not
All
Milord
right,
indicated.
not specified.
Not specified at least. বাড়ি ভাড়া থেকে দেবে আমার and Milord, these Milord dictates, Milord, these last wish Milord of the testatrix were not reflected in the original document.
All right.
খরচ ও মিউটেশন ফি, যতক্ষণ না মিউটেশন হচ্ছে, কালনা ট্যাক্স ইলেকট্রিক বিল, কলকাতা ট্যাক্স ইলেকট্রিক বিল দেওয়া হবে, বাড়ি ভাড়া থেকে দেওয়া হবে। যেভাবে উইল করা আছে, কেউ একজন সই না করলে অসুবিধা হবে না। So Milord, anyone can apply for probate. যে সই না করবে, Milord, kindly see this. যে সই না করবে, here Milord Shashwati did not. সেক্ষেত্রে বাড়ি ভাড়া থেকে তার ওই বিল ও ট্যাক্সও দেওয়া হবে না। So this is a clog.
বাকি থাকবে। Yes.
বাকি থাকবে। সিঁড়ির ইলেকট্রিক বিল শাশ্বতী ভাস্বতী সমান সমান দেবে ইতি তোমাদের মা then she Milord signs Onima Sen. Milord, I was wondering what was the requirement of putting a second signature in English. Milord, if my mother Milord writes me a letter, she would only say iti tomader ma.
So this was produced by them for what purpose?
Milord, possibly for Milord the signature.
Acha, to show that this was her signature.
Possibly.
was produced by them also.
Milord, I'll show from the judgment.
Written objection, they annexed this document.
I'll show Milord from the judgment.
But exhibit 3 means you also produced.
They also relied on this.
They might. Why should you?
This was exhibited by the. They also.
Yes, animation, yes.
So Milord, mother is signing.
And it continues in the next page again.
Yes.
Postscript, sort of.
Here, Milord, she does not sign in Bengali anymore. Milord, she understands that Milord, my signature was there in English. So
She gets tired of signing in.
So everything is written in Bengali.
What's written on the next page? Amaro tomader babar.
Ordinary, Milord, this Odin is my husband.
Acha.
So, Milord, what was the relation between Milord, us, Milord, the eldest, Milord, daughter, the eldest son-in-law? Milord, that is Milord reflected.
Odin is your husband.
Yes. গোয়ায় আমাদের কাজ করার খরচ বাড়ি ভাড়া থেকে দেবে these were Milord nowhere there Milord in the original document so Milord this can nothing but a codicil.
All right.
Milord, if at all Milord this document exists. Now Milord kindly take and Milord this was not Milord prayed a probate for. No application, no prayer was made, Milord, for grant of probate in respect of this Milord purported will read with Milord the codicil. Now, Milord, kindly turn to the application for grant of probate, Milord, which starts at page 2 of the paper book. I'm sorry.
Page
2 of Milord the paper book.
Yes.
Milord, the first sentence in the first paragraph at the foot of page 2. That the writing annexed here to, my Lord, will kindly Milord remember the writing which was being annexed there to was the carbon. So, Milord, this is the foundation of Milord the prayer made for grant of probate. That the writing annexed here to is the last will and testament of Onima Sen. But kindly take the trouble to have a look at the LCR now once. ওই উইলটা একটু শোনো ওই যে উইলটা বার করে দিল অরিজিনাল উইলটাও জজ সাহেবকে পড়ে দিন আস্তে আস্তে শুনে না যায় শুনুন ফ্ল্যাগ ও ফ্ল্যাগ একটা লাগানো রয়েছে Milord, this is what was annexed to Milord this application.
This is a carbon copy.
So-called. Milord, if a carbon copy is made, my Lord will
yes
definitely get an impression of the carbon Milord on the page. Milord, it will be slightly blackened or Milord a bluish color. Milord, it will take.
বলছে এটা carbon copy.
It doesn't appear to be so. It's simply Milord.
No, maybe a carbon copy. I used to type in while I was in class 7. I used to type my father's petitions. If it's a brand new carbon copy, it may come out like this.
Very well.
But we cannot import personal knowledge.
No.
But you can test it out. If it's a brand new.
Can't be any difference, Milord, between the original and the carbon, the first copy and the second copy.
Obviously, there cannot be.
Milord, to my eyes, Milord, this did not appear to be a carbon copy.
May or may not be. May or may not be.
So, Milord, a suspicion.
হতে পারে carbon copy. স্মাজড রয়েছে না টাইপরাইটার এরকম স্মাজড হতে গেলে রিবনটা যেরকম হতে গেলে রিবনের কোয়ালিটি দিস কোয়ালিটি অফ দ্য প্রিন্ট দিস ইজ নট দ্য কোয়ালিটি অফ আ রিবন অফ আ টাইপরাইটার this smudging, a little bit of smudging is there. That is the quality of a carbon paper, not a typewriter ribbon. You have never typed in your life. You have started with computers, Mr.
Milord,
You
started
don't know
with
what
handwriting, Milord.
handwriting, then directly jump to computer. A smudged may or may not be.
Yes.
Yes.
So, Milord, a suspicion is there.
May or may not be doesn't mean suspicion.
Very. Milord, that the writing, Milord,
Maybe
let
a
us take
carbon.
it, Milord, let us assume it, Milord, for the sake of argument to be a carbon copy.
Yes.
That the writing annexed here to is the last will and testament of Animation. She is now referring to this document only. Wife of etc. Kindly Milord turn over the page, second paragraph, Milord, page 3.
Yes.
That a
testator.
Paragraph 2 at page 3. The testatrix Animation deceased left property being premises number such and such and a house under holding number such and such at Kalna, fully described in the affidavit of assets which are within the jurisdiction of this learned court. There was slightly a wrong statement made. One Milord property was there, the other one was outside. Then 3. That the said writing of the will was duly executed by the testatrix on 15th May. Milord, it says said writing of the will. Milord refers to the writing which is referred to in paragraph 1. Said writing of the will was duly executed by the testatrix on 15th May 1994 and was duly attested by attesting witnesses. By the said will, testatrix expressed her wish and desire to bequeath to the applicant and her 2 daughters. Milord, I skipped over, Milord, the description of the property. That your petitioner is the one of the named executrix of the said will, and as such, your petitioner is filing the petition for obtaining probate to the last will of late Animation, deceased. The testatrix by the said will express categorically that your petitioner will be entitled to the grant of probate without furnishing security. That the amount, etc., Milord, I do not trouble your lordship with that. Kindly, Milord, now come to page 5, paragraph 9. Possibly, my lord has marked that paragraph on the last occasion.
Yes.
That the original will executed by the testatrix is still lying with Shashwati, wife of Sri P.K. Roy and second daughter of testatrix, who is at present residing at Darjeeling. The said Shashwati Roy is also one of the named executrix of the said will. Since the said Shashwati Roy refused to apply for probate, your petitioner decided to apply for probate to the last will or Animation. Your petitioner requested Shashwati to deliver to her the original will executed by their mother, but she failed and neglected. On her failure to supply the original will, your petitioner, through a learned advocate, sent a letter. Milord, this letter was never exhibited to Shashwati Roy with a request to send the said will to your petitioner within 7 days. The said letter 7 June 2024. If my lord looks at the exhibit list, Milord, this document was not exhibited. Was sent under registered cover. Unfortunately, Shashwati has not yet sent the same original will. That your petitioner possesses, paragraph 10 then, a carbon copy of the said will, where some corrections were made by the testatrix in her handwriting. Milord, if I go by, Milord, the literal meaning of it, then, Milord, corrections on the carbon copy. Your petitioner is filing the said copy of the will along with this petition and craves leave of this court to file the original will and as and when the same will be received by her from her sister Shashwati. Now, Milord, kindly take these 2 wills side by side. Milord, this carbon copy, Milord, this is simultaneously prepared. Milord, if this is a carbon copy typed, Milord, at the same time.
Yes.
This was just a replica produced at the same mechanical process.
Right.
Kindly take this, Milord, 2 documents side by side. Milord, the original, Milord, which is marked exhibit is in the sealed envelope.
Yes.
Kindly see, Milord, the quality of the signatures, Milord, in these 2 documents. The way A is written in these 2 documents, the ink used.
Right. Same.
No, Milord, sorry, Milord, subject to correction. Kindly, Milord, have a look at the way A is being written, Milord, on the original document. And
First page.
first page and also my lord in the second page. My lord, towards the left hand side.
A of Anima?
Yes, A of Anima.
A little bit different. It may be the no. Substantially same. You cannot go to so technical. Nobody's signature, two signatures tally
And my lord,
exactly.
can you see the tremors
If it
also?
was
Which is my lord,
clinically, then it would be a tracing paper, Mr. Banerjee. Yes. এই তো আমাদের দুটো সিগনেচার আপনি দুটো সিগনেচার করে দেবেন।
but the tremors are also not there, which are there in the original will.
Where is the tremor in first page? Let us
But
come to second
may
page.
I just have a look. My lord, the original.
We find no tremor in the first page.
Please.
Be careful, Mr. Banerjee. Where is the tremor?
My lord has seen my lord A and my lord A of Anima.
We are repeatedly asking whether the first page or not.
Second page.
You are going to the second page now.
My lord,
That
first page
we
in
put you
black.
first page exactly same. No difference. There may be a subtle difference, which is quite normal.
My lord, I am not having my lord that copy. My lord, may I take it once? No. দুটো তো আলাদা.
We would love you to come here and see it.
Yes, we all wanted. We all
We would love you to come here and see it. Is that wasting your time?
Sorry, my lord.
And Mr. Chakraborty would have more practice and it would be beneficial to him also.
But we all wanted him to be there.
Anyway, let us not. Yes. There is more tremor in your hand than the signature, Mr. Banerjee.
You know, the signature differs, my lord, in a sense that my lord, this was not put on a carbon
We'll
copy.
take two signatures of yours
Firstly.
right now on a
And
piece of
second, my
paper.
lord, kindly have a
And
look.
we'll ask your juniors to compare the two. At least 3-4 differences will be there, sir. Because we sign every day so many documents, so many orders.
There
We
will
know.
be some difference. Definitely.
At least my signature varies from order to order. But subtle differences. If it's major, yes. আপনি সব শুধু পড়ে যাওয়ার চান্স আছে এটা কিন্তু আগেও হয়েছে সাবধান থাকুন আমার কিন্তু ভয় লাগছে আপনার আপনি তাড়াহুড়ো করবেন না আপনি দিন না অত হালকা জিনিস
There are two wings on two different pages, which my lord, I also argued on the last day.
Two?
My lord, first page, my lord, possibly blue ink or black, my lord,
Two
second
inks,
page.
okay.
Yes. Two different inks are used.
Yes.
My lord, if I am signing, my lord, on the same date, my lord, it contains two pages. And kindly take me the second page signature.
What is this N? We don't understand. That there is a N. What is
Yes,
this N?
on machine, then there is an N. But I also
That N is what? What is that?
no idea.
N মানে কি?
No idea. No idea.
N মানে?
Original মানে ওটাতেও আছে।
What is N? Anyway, let us forget N.
And Milord, kindly see Milord A of Onima on the second page.
Yes, let us come to the second page.
Yes. Milord, if I am not wrong, there is an overwriting Milord on A of Onima in the second page of the original will. Milord, if I am not wrong.
Maybe overwriting, maybe there was an overflow of ink. That also.
Not Milord, possibly not overflow of ink. Milord, subject
Yes,
to
yes.
of course.
I will give you my pen. Really, we are, and all of us we are saying from experience.
Ian used to get stuck on a
Signature,
point.
nobody does more signatures than us. Not you at least, advocates. Every day. Even not today we have to sign. So nobody knows better about signatures than us. And this may or this is not a suspicious circumstance. This, but use of different coloring in different pages may be a suspicious
Milord, whatever
circumstance.
has passed through my mind, Milord, I will place it before your lordship.
Yes, definitely, definitely.
Now, my lords will kindly take, Milord, there is an office report.
One second. Yes, office report. No, first let us complete the will. What are
Very,
the other
very,
discussion?
very. Milord, the will, Milord, was executed allegedly on 15th May 1994. Milord, Shashwati's marriage was, Milord, on
19th.
19th. Milord, there is no whisper that, Milord, the marriage is going to take place. So, Milord, I want to be quiet and all. And, Milord, I say that, Milord, in a middle class, Milord, Bengali family, Milord, it's highly improbable that, Milord, a mother, Milord, a widowed mother, Milord, she would, Milord, execute a will when, Milord, her daughter is, Milord, going, Milord, for marriage.
What is she supposed to do?
That's not, Milord, possible.
Buy
Milord, the
ornaments,
sweetest time, Milord,
arrange for
a
dowry, and all these things.
Milord, I have never heard, Milord, any, Milord, widowed, Milord, mother hailing from a, Milord, middle class
We have
Bengali
also never
family,
heard, but
Milord, executing a will when, Milord, the marriage is on, Milord, everyone has gathered, Milord, at home.
no, before everyone gathered.
No, Milord, then,
50,
Milord,
4
we
days
all
before.
were there. Then
4
we,
days before.
then we all
We
were
don't know
there,
the
Milord.
number of relatives they had or whether they came over and stayed. There is no evidence on
At
that.
least, Milord, we are there. Milord, the eldest daughter, Milord, the eldest
3 daughters and
son-in-law.
the widow was there.
Yes.
And obviously certain arrangements were being made for the marriage.
Correct.
But that may be a very private affair also, for all that we know. I mean, we cannot assume things.
No, but, Milord, if, Milord, an element of suspicion, Milord, arises,
There
then,
is no
Milord, it would be
commonality.
their duty.
Mr. Banerjee, this
Whether-
is not a category. The 3 categories you referred to, none of those can be valid categories. Middle class, Bengali, and widow. There can be widows of all shades and shapes and mentalities. Similar thing applies to Bengalis. The variety between one Bengali and another is more than any other probably community.
Milord, I looked at it, Milord, from the angle of my own mother.
No, look at other mothers also. You go and look at others' mothers. Then you will get an idea. Just look around you. The variety of shapes and sizes that Bengalis come in. And middle class is, middle class is what? It's not a category.
Not a category.
There is
but,
no
Milord,
middle class at all.
Milord, I thought, Milord, this is highly improbable, Milord, a thing that, Milord, when, Milord, everyone has gathered, Milord, there is a social marriage.
We don't
everyone
know
is
whether
fixing
anybody
marriage.
gathered on 15th.
Yeah, that-
19th is the marriage date.
Correct.
So for all that we know, Mr. Banerjee, they might have had very few relatives. We don't know. These things are entirely your and my assumptions.
But this would help me, Milord, while I'll be, Milord, scanning the evidence of the witnesses, Milord, who had deposed. Milord, whether
Was there any evidence? Because if it came in your evidence that there were people in the house, all of these are your inventions you are making out when you
No, not, Milord, my
when you are in a conference.
No, not my invention.
A
Really,
middle
Milord.
class Bengali widow, what is she supposed to do 4 days before the marriage?
But, Milord, I thought, Milord, that
Executing a will, why is it so surprising? I mean, she's giving off a daughter in marriage and
Yes.
she's bequeathing her properties to some of the properties, lesser amount to the daughter who is going to be married.
depriving someone who is, Milord, then there.
Depriving, yes, you are different. Sorry. Giving more, a little bit less property to her middle daughter, a little bit who is going to be married, a little bit more to the younger daughter,
Youngest
who may be the favorite for all that we know. And you
Milord,
may be the least favorite. So what is the suspicion in that?
suspicion is, Milord, why, Milord, may I put this question to myself? Why would my mother then choose a time, Milord, to deprive me when, Milord, I am around?
Don't get it. We don't get it. What do you mean?
Milord, I was deprived, Milord, according to me, because Milord, I was bequeathed upon, Milord, a property which
For
had,
the
Milord,
Kalna property.
Kalna property,
Yes.
which, Milord, is no match, Milord, for the Kolkata property. Now,
Obviously,
Milord,
yes.
now, Milord, that instrument was executed at a point of time, Milord, when I was there, Milord, at home, at my, Milord, paternal home. Milord, that might not have been, Milord, the right time for my mother to do this because she knew that, Milord, I am going to be deprived. Milord, she could have done this, Milord, in a more comfortable way when I was not around. Milord, if it doesn't, Milord, characterize me that's different, but, Milord, I was thinking it, Milord, from that angle.
Bengali middle class story, narrative of a film.
Milord, I was thinking from, Milord, Bengali middle
You're
class
starting
angle
from
only.
Sondhanani's era. But we have changed that.
Very well, Milord,
Bengali middle class widow lady may very well execute a will 4 days before the marriage of one of her daughters. Why not? I mean,
I have never
that
seen,
may,
Milord,
that
any
may
lady,
even
Milord,
prompt her to be, introspective. That one daughter I am giving in marriage. I mean, if you are on assumptions, there may be various shades of assumptions. If I am the mother, I am a Bengali widow lady, middle class, as you say. So if I'm going to give one daughter in marriage, another daughter, other two daughters are there, I may think it fit that, yes, let me distribute the properties also. Life is transient. I may think that also. Why not? I mean, where is the bar? Where is the suspicion in that?
And Miller, the attesting witnesses are
Suspicious circumstance happens when immediately several cases come to all of us. Probate is applied for on the date of the Shraddh ceremony, suppose. These are suspicious circumstances. The person, the testator dies on the date of the Shraddh ceremony, or in between, I apply for a probate. I couldn't wait. These are suspicious circumstances.
Miller,
But marriage
when all
is
the
nothing.
near relatives were there, Miller,
Don't know.
Minute,
You may not have any near relative.
When I'll take your lordship's minute to the deposition part
Are
of
there
it.
depositions?
There are depositions.
What are the depositions? What do they say?
May I, before I take your lordship to that, two more things. There is an office report. Kindly, just have a look at the office report of 7th September 2020.
What does it say? Tell us.
It is just say that, these exhibits, exhibit 1, 2, 2A, 3 and all, up to, exhibit 5 and then exhibit X. These are, defective. LCR is defective because these, do not bear the signature and seal of, the learned trial court.
XYZ.
Kindly, have a look at the report once. In exhibit 1, 2, 2A, 3, 3A, 4, 4A and 5. There is an office report to that effect.
What is the number of the will is included in that?
No, will is not included in that.
Then what is the difference?
The other exhibits,
what are those?
Those are signatures of the
signatures on the will.
Not on the will. Not on the will. On the other document.
Any material.
On the other document.
If it's a signature on exhibit 3, then don't argue that. Yes, then don't argue on that. If it's on exhibit 3 is included in that.
Exhibit 3 is included. 3A is included.
Then your codicil argument goes.
No, it doesn't, Otherwise, this was marked exhibit. The seal was not there. That was the office report. I bring
it's a mutually contradictory argument.
I follow. I understand that. But this was possibly my duty to indicate that also. Now, this probate application was filed on 17th of June 2004.
We are having real tremors in our. Mr. Banerjee, something better than this.
This tremor part of.
Tremor part. No, better than the middle class widow lady.
Subject to partition, my lord.
You are also there?
Yes, my lord.
He was in court. He gone back home.
No, he is appearing for whom?
He's leading us. He's actually taking advantage of the resolution.
He is he's appearing for the testatrix. You are appearing for whom? Leading you?
Leading us.
Yes. Mr. Banerjee, please continue.
Yes.
Let us do.
The markings are there. Subject to partition, my lord. All the markings are there. The signatures are there. Page 3, my lord. By the judicial officer. Page 3, your lordship, right? The middle portion, yes, some middle portion, exhibit 2, signature of the judge. All are there. Subject to partition, my lord.
Lord, here,
yes,
the exhibited, Lord, the compilation that we have handed over containing the exhibits.
Yes, middle portion
of the judicial officer is there everywhere.
The signature is there. The office report says the seal is not there. That's
Anyway,
what the office report
forget
says.
that.
Yes. Now, the application was filed on 17 June 2004. Probate was initially granted on 7th November 2005. Then, Order 9 Rule 13 application, that was allowed. The matter was heard afresh. And, when PW2 was, examined, he was not brought, for cross-examination in full. He fled midway.
PW2 is one of the attesting witnesses.
The sole surviving attesting witness.
He refused to face the total cross-examination.
Yes, he did so.
The law is that if substantially he has been cross-examined on the relevant points, then it can be taken. Otherwise, no.
There was a revisional application filed. I'll chronologically take your lordship to that. The revisional application, coincidentally came before your lordship only. And my lord passed a judgment, my lord, saying what my lord has just now, my lord.
What it is?
That my lord, if
Oh,
my lord
just now.
substantial, yes. Is
So that is
substantial.
the law. There is judgments on that.
No, and my lord, a liberty was given, my lord, to the learned court below, my lord, to decide whether, my lord, he should be
Yes,
tasked, my lord, to appear for further cross-examination or not.
What happened after that?
The learned trial court asked him, my lord, to appear for further cross-examination, my lord, he did not.
I think he appeared.
No.
I think he
No.
appeared.
My lord, I'll show, my lord, from the order sheet. My lord, kindly take, my lord, the order passed by the learned court on 1st February 2016.
Where do you get that?
My lord, the LCR, my lord, the order sheet is
LCR,
there.
don't you have a compilation? Why don't you bring a typed copy of this? In every matter, the documents exhibits you can understand, Mr. Banerjee, but if for the order sheet and everything we have to look into the LCR,
Maybe, my lord,
it
then
will be
apply
cumbersome for us.
That's true.
There would no purpose to a paper book then. There is a paper book in the matter. So what is the use of the paper book then? Paper book should contain order sheets also. Oh, the banking paper book.
My lord, we may not examine the
Paper
LCR
book
and then
prepared
only
under the
we
Surface
also, my
Act.
lord, could come to learn about this. My lord, these things were not known to us also. My lord, may we, my lord, then apply for certificate?
What is there? You have a copy, read out.
I don't have a copy, my lord. I just took note of it.
No, yes, read out what you are trying to say.
Yes,
We won't look into any order, you make your arguments.
Right.
What happened in that order? By that
My lord, DW, I can tell you, Lordship. My lord, on 7th of March 2017, my lord, there was an order passed, my lord, by your Lordship's court, saying that, my lord, there would be a stay of all further proceedings till my lord decides the question whether my lord PW2 my lord should be allowed to be cross-examined or not.
That is immaterial.
Yes, no, my lord, after that, what happened? My lord, on 8th of August 2018, the learned trial court will have passed an order saying that PW2 should come forward for facing the cross examination. Then he did not appear and his witness action remained incomplete.
Mr. Banerjee, you can do this. You can ask your sub-junior to take down the crux of this order where PW2 was directed to appear.
Very well.
Is it a longish order? It should not be a longish order.
It is, so far as my recollection goes, dance in 1.5 page.
Oh.
But we can do that.
I recollect having taken down an entire the entire deposition of both parties by hand. Throughout the day, I took leave from the court and did that. So 1.5 pages is not much.
No, we will do that. We will do that.
Because we did not have time to take out a certified copy. It was already on the board being parted. Judge did not grant us time. Anyway, so court directed PW2, PW2 did not come.
Did not
So
come.
do you say adverse inference should be drawn?
Yes.
Or that evidence should be overlooked?
Yes.
So if
And
that
he was
evidence
the only person who
that is
identified
overlooked, then
the-
no compliance of 68.
Then the will remains
unproved.
Yes. Now kindly also have a look at the declaration made by
We'll
the,
request a short written notes and we'll put these points there.
I will do that. I'll do that.
We are taking our notes, but you put your points. Yes. What else?
Milord, in the probate application, Milord, there was a declaration at the foot of the probate application made by Milord, the sole surviving attesting witness. Milord, he filed Milord a separate affidavit to that effect.
Yes.
Milord, the declaration, Milord, given Milord in the probate application, in the affidavit filed by the attesting witness and the declaration made Milord at the foot of the will, Milord, are different. Milord, page 13 of the paper book, Milord, there is a declaration made by the attesting witnesses. They say that, Milord, they signed, Milord, this document in presence of everyone and also in presence of the testatrix.
Yes.
Now, this attesting witness, Milord, PW2, Milord, who did not, Milord, make himself available for cross-examination in full, he filed an affidavit before the learned court, which I could, Milord, come across while, Milord, scrutinizing the LCR. There,
that's
Milord,
also not a part of this paper book. No. So what did he write?
There he says that, Milord, he has signed this, Milord, in presence of the testatrix. Milord does not make a whisper with regard to the other attesting witness.
That is not that is not mutually contradictory. That is signed
The
in presence of the
requirement-
testatrix.
The requirement of law is possibly, my lord,
Requirement
everybody's
of law has to be proved on the witness box. If he said yes, that barring that he did not face cross-examination part. Otherwise, if the evidence is if the evidence is accepted, then he has to do it in the witness box.
Yes.
Declaration need not contain anything. There is no law under either no provision under the Indian Succession Act in the declaration. It has to be done. Only section 68 and 63 is there, Mr. Banerjee.
63 says that, my lord, everyone has to be
63 is
present
that thing,
simultaneously at
yes,
the same
and
time, my lord.
68 of Evidence Act that it has to be proved by at least one.
At least one
How
witness.
proved it is not there. His declaration may not contain the entire thing. If it was contradictory, and I did not sign in presence of or something like that, then you would have a
Says
good
he
case.
signed it, my lord, in presence of the testatrix.
That much is common in both.
But, my lord, he does not speak about, my lord, the other, my lord,
Need not.
attesting
In a
witness,
declaration,
whether
he
he
need
was
not.
there or not, my lord, that is, my lord, possibly
In a
missing
declaration,
there.
he need not. The affidavits in support of the probate application, in that he did not say that. He said that. The affidavit which was filed in support of the probate application, that was correct. That said that it was signed in presence of all.
No, my lord, there, my lord, he did not say that, my lord, it was signed in presence of
That was
all.
done by the other attesting witness.
The other attesting witness had died, my lord, long back.
No. Who filed the probate? The probate application was filed by the. No, attesting witness filed a declaration. Only the sole attesting witness.
Sole surviving attesting witness.
Right.
Who was PW2, my lord, who was not cross-examined in full, could not be cross-examined in full.
Oh, his declaration did not.
His declaration, my lord, is something, my lord, contrary to what he said, my lord.
Not contrary. But
Not in consonance, my lord.
Not in consonance.
Not in consonance.
And not in consonance with section 63 also.
That's, my lord, my case.
Put that point in your written notes.
But,
We'll
my lord, I
consider
must
that.
show those things, my lord, from the LCM, my lord. May I then, my lord, take a note? My lord, I have taken a short note of it. My lord, the exact language in which, my lord, the affidavit is couched, my lord, that is to be placed before your lordship.
We can hand you over the LCR, but LCR will get damaged every time if you hand over and if you hand over back to it.
No, my lord, I do not need it now. My lord, may my learned junior, my lord, just, my lord, copy, my lord.
Take down and have it typed and give a copy to them and we'll take it and take that into it. You'll get some, no, you will not get anything. Tomorrow is the next date for hearing.
May it be then, my lord, on Monday, subject to minus kind, my lord.
No, only that application, that declaration
And
part.
the orders also.
One order.
There is my lord's order, my lord, 3 orders.
My order was irrelevant.
The 3 orders of the learned trial court.
My order, you don't have, you cannot have a server copy.
Server copy, barcode. Yes, my lord, we have that. We have that. We have that.
That order would be necessary.
3 orders of the learned trial court, my lord. Once, my lord, he is called upon, my lord, to come and depose. The second says, my lord, he is not coming. Third says that, my lord, he has not come.
That must be cryptic. Most of them must be cryptic.
Short orders. One is one.
So take down those orders and have them typed after we rise today.
Very. Now, my lord, may I, my lord, take your lordships to, my lord, the witness action.
That is there in the paper book.
That is fortunately there in the paper book. My lord, my objection, my lord, will get at page 14 of the paper book.
Yes.
My lord, this was principally on, my lord, that marriage and all.
Oh, that was in your objection also, you said?
Yes. And, my lord, I said that, my lord, we had a wonderful, good relation. And, my lord, it was, my lord, my husband
So
only.
the 3 key expressions you used were there in that. Not there. Achha.
My lord, page 14, my lord, my objection starts.
Yes.
Kindly take, my lord, page 16.
16, yes.
My lord, paragraph 10. My lord, last 4 lines of paragraph 10, immediately above, my lord, paragraph 11, I say, my lord, the other 2 sisters, my lord, they colluded, my lord, to deprive me.
Clever ruse between Vasuti and Saraswati.
Yes, yes.
All right.
Then, my lord, I narrate the facts where, my lord, at page 17, my lord, I say, my lord, the relation between my husband and my mother was, my lord, like mother and son. And since, my lord, the
Where do you say
other
that? Page 17.
Page 17, paragraph, my lord, 11.3. My lord, may I proceed for your lordships?
Yes.
In the absence of any son, because my lord, they had, my lord, we are
The
three.
others had no husbands till then.
Yes.
No, obviously.
Yes, yes.
It's
my
very
lord.
natural. Yes.
The husband of the opposite party practically became the eldest son of the family for all purpose ever since his marriage. Late Onima Sen, there before Shorendranath, her husband, or both of them, consulting him for all purpose in most matters, he being always accessible to the family members, both Shashwati and Bhashwati were of very tender age. Late Shorendranath, my father, was the absolute owner of all the properties, etc. It is worthwhile to state that all such fortunes descended on Shorendranath from his late ancestor. However, Shorendranath, not having any son, he consolidated the property in the hands of his wife through an will of 27th August 1983 in respect of the house at Devaprasad Row, the only property worth the name in the hands of the family. It is pertinent to state that this property alone shall be a crore or more. You know, which is why, my lord, we are saying that the Kalna property is no match, my lord, for the Kolkata property.
You are married off already. You are in good hands, in the hands of a person whom they consider to be like their son. So why should you be given the better portion of the property? You have been married for long. You are settled in life. One is going to be married a few days after. Another is not yet married. So the lion's share of the property was given. Lion's share of the property was given to those unmarried people who are not settled in life.
Other properties were sold for their marriage, for the marriage of my 2 million.
That is for the marriage, but they have to be
For the
settled also.
They were also given in good hands, in marriage.
They were. No, one was being given.
One was being
The other was not yet.
Not yet.
When the will was executed.
True.
You were already in good hands.
That is not explained in the will. If there is a disproportionate distribution.
Everything need not be written in a will. We have to
There-
find out the suspicion from the circumstances also. You have to prove that there was a suspicious circumstance. One daughter is married, as you are using the three expressions now coming. That would be the mindset of a person like that, coming from that background. I have one of my daughters who is married for some time, in good hands, with a person, living with a person. Her husband is like a son. So you have full faith in that person. This appears from your application. I mean, not in so many words. But then why should I give her the lion's share? I'd give the lion's share to the other daughters, one of whom is going to be married. It's uncertain how she will fare in her married life. The third daughter, not yet married.
That all this
So because the mindset you are relying on, that middle class, whatever you said, that may, from that mindset, from that perspective, one may consider that a person is settled, a daughter is settled when she is given in marriage.
Then she would have said so, in her will.
Need not
That,
have.
these are the reasons
Need
why
not have.
I'm
There is no
giving less,
compulsion. There is no you have to show the suspicious circumstance.
True. But
court in its judicial conscience does not find anything so gross that the court should embark upon an inquiry of itself because of the circumstances which you are telling you. And then the burden shifts on you. You have to show there was a suspicious circumstance. What did you do to show that it was such? Apart from saying that I, like a crybaby, I got the Kalna property, she got the Devaprasad Ghosh property.
And there was no reason, for this discrimination where it's spelled out. And all through, we are having, good relation. That's what, is said, in my written objection.
Till she executed the will.
Then, kindly take paragraph 11.8. I have explained, my husband's role in the family. Just to impress upon your lordship that my husband was also there, which will come from that witness action when the will was allegedly being executed. He was also there in his in-laws' house because of the marriage of the sister-in-law, and because of the relation that my parents would share with my husband. She would have been the first person to be called upon to sign the will as an attesting witness.
Who?
My husband. Every faith, trust, that was reposed in him. He was the person who was taking.
That would not be prudent because his wife is being deprived.
If that
I'm giving a property to my other daughters, I'll call the just to rub salt in the injury.
That is another angle, from which we can look
There are
at
several angles. The moment there are several angles, Mr. Banerjee, it becomes conjecture. It goes into the domain of conjecture. Suspicion has to be evident from the circumstances of the case. The evident thing which is there in the circumstances, which, as you said, one of the daughters is given the bad property in Kalna, and the other two daughters, the better property, the much better property is incomparably better, you may say, is given to, although we don't know the dimensions of the Kalna property. Because the Kalna property may be very good also. We don't know the,
that is not bono.
but no match with this,
Yes.
Deo Procedural. But that is only the only thing you have. And one
but
of the
the
daughters is married, settled in life. The other two are not yet.
And none of the attesting witnesses has also said that this was executed in carbon copy also. I signed.
Carbon copy, even if he, I mean, ignore
Discard
the
carbon.
Discard, ignore the carbon copy. They prove the original will. After that, what remains?
Then with the story that there were two copies, I'm putting the carbon copy now. If my sister gives it, I'll put
Carbon
the
copy has been
original.
produced.
True.
Has been produced.
True. But the carbon copy, none of the attesting witnesses says that this was, no question was also put to
Carbon
them.
copy, they say there was a carbon copy. That carbon copy has been produced. Original will has
This
been
carbon
produced.
copy then must have been signed, at the same time, in presence of the attesting witnesses.
Yes, if so, what?
But from nobody's evidence, that has come out. That the testatrix had two copies of the will before her, and she
there is
signed.
no requirement under the law to prove any signature on a carbon copy.
Then the story that
story is that a carbon copy was made, Mr. Banerjee. Nothing else. There the story ends.
So
is it the story? Is it the story of the petitioner, of the propounder, that the carbon copy was also equally attested like a will and all these things? The only story is that there was a carbon copy made out. They have produced a carbon copy. Their job ends there.
And she says this is the original will. That's what the first paragraph of the probate application says.
That's obviously a misnomer in view of we have to read the plaint as a whole. So if you read the plaint as a whole, the last few paragraphs categorically say that she has not sent the original will. And I have already written till date, as yet, that is the language is yet not. So there was a chance of her producing it later, which she did, it was produced.
Then this so-called original will came through an application filed by Shashwati. Before the learned code below, when
will was produced and exhibited.
True.
Whether by an application from somebody else. So what is the matter? She is also one of the daughters, one of the beneficiaries. Initially, she was adamant.
And she was not examined, why this original was with him or with her.
Why should she be? The execution of the will should be proved only. These are ancillary, yes. These are ancillary and tertiary facts, not even ancillary. Till now, the best case is probably your mismatch of ink. Ink is very crucial. Two colored ink into two different pages and only 2-page will.
And the relation, because of the relation, that was shared.
Always somebody is deprived in a will. That is the purpose of a will, Mr. Banerjee.
Otherwise, why would one?
Why would one execute a will at all?
Intestate.
Yes, intestate succession. Purpose of will is to deviate from the line of succession. She might have her favorites. We don't know. You say that
something more in my objection to the probate application, which I think though I could not prove.
You say you feel that your husband was seen as a son by her.
Yes, and then I say that my mother had
That's
always
your perception.
My mother would always tell me that the property should be equally distributed. That's what my averments are there at page 18.
Your mother is not there to come and say that yes, I see. These are your objections. These are your entirely your barren.
But I could not prove that. That's true. Accepting my husband's role, in the family, and this collusion and coercion, I have pleaded at page 19.
Husband's role, what have you proved? What is the evidence on that?
Husband's role, in the family, that he used to take care of his mother-in-law, his father-in-law, and they had a very
What
good
is the
relation.
proof on that? What is the evidence on that?
Then I'll take your lordship.
Is there any third party or
no?
You yourself said my husband took care of the family.
I was the only witness. Nobody else was examined.
Was your husband brought even?
No. I can't improve on that.
Does he know that he took care of the family?
What has happened before the learned trial court, those are there before your lordship, so I can't improve on that. Page 9.
We are sitting in appeal over a judgment of a competent court. which is equally a court like us. Only the appellate hierarchy is different. So we have to honor the view taken by that court. If there is something wrong, definitely. Mismatch of ink in 2 pages,
And
till now
Milord,
the best.
no whisper in the will that Milord,
Why?
this will was read over and explained to her in Bengali. Though Milord, she has signed in English.
Signed in English. Where is the question of reading over and explained?
Milord, there was a question put Milord to PW1, Milord, the propounder.
Yes.
Milord, what was Milord the English knowledge? Milord, how educated Milord the testatrix was Milord she capable of Milord understanding this or not?
Mr.
She said she
Mr.
Milord
Banerjee,
studied
we
up to
understand.
5-6.
We understand. There is a catch in this logic of yours, because this reading over and explained concept stems from originally Pardhanashin concept borrowed to illiterate persons. So the entire line of judgments which you find is on Pardhanashin or applying that concept to illiterate persons.
Or who is not capable of understanding Milord the legal language or Milord the...
No. That is a second legal fiction you are creating. Then in every case where a will is drafted by an advocate, it has to be proved that it was read over and explained. We cannot go so far. We cannot doubly extend a legal fiction. There cannot be a fiction on a fiction.
Fortunately for us, Milord, there
Have you found any judgment where then in every will which is drafted by an
not-
advocate? And why that? If I practice in the criminal side, if I execute a will, then it has to be proved that the connotation was read over and explained to me, even if I am an advocate. Because I don't practice in the civil side, I don't have any idea. If I am a revenue practitioner, I am an advocate. Then also I am an advocate, but even then
But
it has
Milord,
to
a
be.
lady who studied up to class 5 or 6, Milord,
Don't
she
have any
was-
idea. Most of the business houses in our country is run by those business houses, Mr. Banerjee.
Not a good day for me, Milord. Before Lordship, Milord, I can understand
We
that.
are telling you, we are taking up the Birla matter. We are telling you, Mr. Banerjee, really, some of the ladies in those families who run the entire country now, the economy of the country, some of the ladies of those families are much more sophisticated than any of us. The classes up to which they read would surprise you.
But I only heard of
That is not a measure at all. Education is not a measure at all in worldly affairs. Nothing. We know nothing. Education.
She used to have to do this, filing the tax return.
Okay. He has to say something. That's what he has said. Just English, sir.
Then, Milord, paragraph 11.12 at page 19, Milord, that collusion and all, Milord, those. And I say that, Milord, she was suffering from cardiac ailments.
That's why she.
But again, no proof of that, nothing. And, Milord, kindly take note of page 20, paragraph 11.14, where, Milord, I have dealt with, Milord, the educational qualification of the testatrix.
No, you have a point there that if the will
I
is
say
in
that,
English.
Milord, she was not literate enough and was unable,
Right,
Milord, to speak, write, and understand English.
No, this cannot be brushed aside. You are right. You have a point there. But the question is whether this reading over and explained concept should be extended beyond what the courts have held it to be.
But whether she had the mental capacity, Milord, of understanding what is written over there in those 2 pages, Milord, that was, Milord, the point, Milord, I was trying to develop. And, Milord, no evidence possibly, Milord, came before the learned court to show that, Milord, she was capable of understanding this.
Was any question put in counter regarding that in their cross-examination by you, counter session on that?
There was a few. There were a few, Milord.
You
There
show
were a
us
few.
those things.
Yes.
Because those may become relevant.
Yes. Milord, unless, Milord, I go to the witness section, Milord, all these things are, Milord, in air.
Right. So let us
Milord,
come to the witness action. Start. Yes.
Milord, the examination in chief of PW1, Milord, the propounder, Milord, is at page 25.
Or should we start the witness section on the next day? We have 6 minutes. Let us give 6 more minutes to your learned junior to copy those things.
Lord, I would also like to have a look at the LC.
Yes, definitely. Yeah.
What I could recollect.
Both sides এর অ্যাডভোকেটরা না হয়ে যাওয়ার পরে এই ফাইলটা একটু দেখবেন, এখানে বসে দেখবেন এবং তার থেকে কিছু নোট
come back on a better day.
সেটা পারমিট করবে।
If I could recollect correctly, Lord, after your Lordship's order in the civil revision, I was representing in the city civil court. the PW2 he came Lord to depose after your lordship's order.
You
I
check
was
that up
there.
also because
I'll
you'll have to
check up
answer
and-
this question.
Yes, I'll check up and I'll take that Lord.
Yes, yes, you should
That
take it.
according to something else that they did not examine.
Stand up once and then Milord.
Well, I was there, Lord, personally. I'll try to recollect.
Hey, Mr. Rai, what are you saying?
That he appears they did not examine further.
Yes. He appeared, they did not cross-examine. He appeared, he came.
Then you have to take
Yes,
it.
I'll take
That's why I did not disturb your lordship.
Paper book should have been proper. The orders should be there. The relevant orders, everything you rely on should be there in the paper book. Why should you look at the LCR every time? And these are the LCR, the condition of the LCR. This is still better. Some of the LCRs, I mean, we cannot take a risk on that. And we are a court of records. If one of the orders are, one of them go missing, it will be, I mean, bad for us. Take inspection of whatever you have to do, and you also help your juniors to guide them what
Yes,
they have
Milord,
to
I will
look at.
give Milord my note sheet. Milord, the relevant dates
Wait a
Milord,
minute.
are indicated here.
Second.
Milord will keep it on.
Maybe then Milord come back Milord instead of tomorrow, Thursday.
Very well. Very well.
Lord, only one request, Lord, most humbly request, Lord. Mr. Banerjee will address
Come to
your
the
lordships
request.
on 17th. Lord, our reply may be given on the next Thursday, Lord, 24th. 17th, I'll not be here physically.
তোকে বলতেই হবে
Mr.
না।
Rai, I don't know whether he is there or not, Lord.
I'm an idle advocate. I'll be there.
Let him finish on 17th. We'll take note, Lord. I'll join
What is the
virtually.
difficulty in coming back tomorrow? I mean, you take note of
that note, Lord. I will have to type it down, Lord. I can do that, but Mr. Banerjee, he may
Milord,
not
my
be.
learned junior Milord needs to Milord take note of all the orders. Milord, I do not want to do this
For us, Lord.
Heard in part for further hearing on April 17. Heard in part for further hearing on April 17, 2025.
And we'll give a reply on 24th April. My Lord. Only that.
I
that
will not record that today.
But a caveat I'm trying to.
Gratitude to Mr.
No, we'll forget on that day. we assure you that. কোথায় গেল ওরা?
And we are not sure on 17th what will happen here. On 17th, what will happen?
Something must have been 16th and 17th. Yes.
দুদিন ছুটি কিছু তো হবেই।
Don't push anybody off the balcony. That is the only request we can make to you. And ensure that Mr. Basu does not do it. Mr. Saptangshu Basu.
আরে বাবা, উফ। একটু দেখবো জজ সাহেব উঠে গেলে, হ্যাঁ?
Grateful to your lordship.